So, very nice to see you all. And we're going to start with the paper from Vicky Barnes and Sally Wheeler called Shaking Up the Savoy. And as you can see, Vicky is here to answer questions. Can I just check, Vicky, are you able to stay till the end of the session, or would you like to take questions immediately?
No, I'm really, I'll be here all the session. I always like
Okay.
questions at the end. I think
Yeah.
they're quite nice.
So let's agree that we'll do 20 minutes each and questions at the end then. That's great. So I think Gemma is going to share a video of Sally giving the paper, because Sally can't give it because she's traveling.
Hi everyone, I'm sorry that I'm having to do this as a recorded presentation, but I'm travelling for ANU in my time slot. So perhaps I could begin by acknowledging and celebrating the first Australians on whose land the ANU is situated, the Ngunnawal Ngambri people, and pay my respects to their elders past and present. It is their land taken by fiat and by force, and one which hopefully the new Australian government will make some effort at recompense, renewal, constitutional change. So the contribution that I give today on behalf of Vicky Barnes and myself is a contribution about the emergence of hostile takeover bids in the 1950s, and one particular such bid, the battle for the Savoy Hotel. Although, as will become clear, it was actually the Berkeley Hotel that was owned by the Savoy Group that the takeover bidder wanted. The Savoy had been in the ownership and patronage of the D'Oyly Carte family. In addition to being Winston Churchill's favourite place to dine, the Savoy was also the first place in London to mix and serve cocktails. So it was an establishment that embodied both much-loved traditions and an appropriate level of innovation that meshed with generations of British society. A hostile takeover is a takeover in circumstances where the board of directors of the target company do not recommend that the target company's shareholders accept the offer that's being made for their shares. And the slide I've just put up is a Berkeley Hotel. Now, the Savoy Hotel bid was not the first hostile takeover bid of the 1950s. That was the takeover by Charles Claw of Sears, and there he is on the slide. Now, the most interesting thing about the takeover that Charles Claw did with Sears was that he was able to use direct mailing to Sears shareholders to tell them about his offer. Previously, offer documents for share purchases would always have gone through the board of directors of the target company. And we might speculate that Claw's approach of direct mailing became possible because in 1953, paper rationing ended. And Claw has a bit part to play in this story as well. And of course, the Institute of Advanced Legal Studies, which this conference is hosted on behalf of, is housed in one of the buildings that celebrates Claw's substantial contribution to philanthropy and support of education and the arts. So why did hostile takeover bids emerge in the 1950s? Well, pre-1950s, there were cooperative mergers in the 1920s, so pre-World War II, as the UK moved away from being largely family-run enterprises. And there's an argument that Chandler makes that's contentious with economic historians, but is largely empirically true, if not for the reasons that Chandler gives, that there is a wave of takeovers in the 1920s that start to change the relationships around shareholdings and board control in the UK. And we can look at GKN, Schweppes, Cadbury, all of which that actually happens. We see shareholdings become more dispersed. We see family ownership start to be concentrated within board membership rather than family control, concentrated with board membership rather than share ownership. So post World War II, this dispersed share ownership means that takeovers are more possible. You can do it through share acquisition because you no longer need to acquire the whole company. You can do it through acquiring control because there are more small shareholders and you can buy up their shares. You've also got a transition to professional management, which meant that corporate earnings were largely retained for investment in the business and not distributed as shareholdings. You've also got relatively high inflation, and that encourages managers to hold back from cash distribution and instead create funds for asset replacements. You've also got low dividends as a result, and in fact, Labour government policy between 49 and 51 was of dividend restraint. And in support of that, you've got corporate taxation rules hitting declared profits. So this was a further incentive for managers to push down dividend levels and not spend much distribution to shareholders. Dispersed shareholding means that individual investors can't push management to give them a better dividend. They're stuck with the deal they've got. And low dividend levels meant that share prices didn't reflect growth in asset value. And compounding that was the fact that a lot of corporate property had not been valued since before the war. So what was on corporate balance sheets as asset value didn't reflect post-war property values. And post-war property values increased dramatically. If you think about the facts of high trees, you've also got the Sears takeover evidences this. I mean, Charles Claw launched his takeover attack on Sears when he found out from an estate agent that Sears' balance sheet underestimated the real estate value of that firm's 900 high street stores by £10 million. £10 million in 1953 was worth an awful lot more than it is. And in fact, it is the property value of high street stores that is still a key rationale for acquiring these sorts of chains. People talk about Philip Green of British Home Stores, Topshop fame, as being a retail genius. He's not a retail genius at all. He's a property speculator. He chooses what chains to buy on the basis of there being a disparity between the stated book value of property and what it's actually worth on the open market. Also in 1948, there was the 1948 Companies Legislation, which required much greater accounting disclosure from companies than before, and there were post-war changes to accounting standards. So taken together, this made the identification of firms that would be good for a takeover much easier. You no longer had to rely on the target firm giving you information. It was actually publicly available. So shares were cheap to acquire compared with the profits that could be made on selling companies' assets. And the slide I've got up at the moment is tea at the Savoy. It's not a 1950s period photograph, but it gives you an impression of what the Savoy was like and why people were keen to hang on to it. Acquisition was also made easier by the 1929 Companies Act, Section 155, which allowed a purchaser whose offer had been accepted by 90% of the shareholders to force the remaining 10% to sell their shares on the same terms. And in the 1948 Companies Act, that becomes Section 210. Now, in the case of the Savoy, there was a particular reason for trying to acquire its properties. There was a shortage of office accommodation in central London. The scale of post-war building was scheduled to deal with that supply issue, but not for several years. So acquiring the Savoy group of properties in 1953 was attractive to developers. It would have been less attractive later on in the 50s. So usually the strategy on taking over a firm was to replace conservative managers with other managers prepared to sell assets to maximize returns and often leasing back those assets so that the company now paid rent on an asset it formerly owned. Or new management increased dividends so that the share price rose, and the shares that had been bought to make the takeover work could be sold on at a large profit. Both of those strategies were very possible because of the way capital profits were considered not to be taxable. If a company sold a fixed asset, those profits were not taxed in its hands or in the hands of anyone receiving those capital profits as part of a distribution. So, in addition to the Savoy and the Berkeley, various other landmark London properties were in the same ownership. The Savoy Theatre, Simpsons on the Strand were all part of the Savoy property group. These ownership links were not commonly known. Now, increased trading in the Savoy Group shares began in the middle of September 1953, and the Savoy at that point had 4,000 individual shareholders. By November 1953, the share price had doubled from 25 shillings to 50 shillings. This rise, coupled with trading by nominee companies, led the Savoy directors, rather belatedly one might say, to realise that this was a takeover attempt. And they also realised that the takeover attempt was for the Berkeley. The Berkeley was a loss-making hotel. By 1953, its properties were 1/20th of their 1945 level. The building and the site were together valued at just under 500,000. A sale and lease back would generate a distribution to shareholders that would never be matched by continuing to trade as a hotel. It was a classic takeover scenario. The bidder was unknown. Now, at first, the directors thought the bidder was Charles Claw, and there's another photograph of Charles Claw. And he was sounded out on this by the Savoy directors. He denied being the buyer. He offered to make an offer for the Savoy shares in exchange for a seat on the board. And he said that he wouldn't make any management changes, but he wouldn't confirm or deny that he might sell property from the group in the future. And the Savoy directors rejected this. Under Section 164 and 172 of the Companies Act 1948, the shareholders, or a certain number of shareholders, can make a request to the Board of Trade for an investigation into the ownership of the rest of their shares. And the Savoy board made this request. An inspector was appointed and the share price stabilised. By then, the mystery raider was thought by the Savoy board to be Harold Samuel. And there's a photograph of Harold Samuel. He was chairman of a property group called Land Securities Investment Trust. And he'd already made a number of very successful post-war transactions in property, albeit not in London. And his catchphrase is one that we've all become quite familiar with. So the directors of the Savoy realised they have time to create a defence strategy, as the Board of Trade investigation will not report until early December. And after some manoeuvring and legal advice, they settle on a strategy that ensures that even if Harold Samuel gets control of the Savoy shares, he cannot do anything about altering the Berkeley's business as a hotel. The defence strategy is built around the creation of a company called Worcester Building Company, London Limited. Now, why would they choose that name? And I think the Savoy directors chose that name as a joke between themselves, or at least a shared conspiracy, because they had guessed that the bidder was Harold Samuel. And why did they choose Worcester? Well, they chose Worcester because Harold Samuel and someone else who plays a bit part later in the story, Max Joseph, had spent their war years hiding in that bungalow in Badsey in Worcestershire. Samuel and Max Joseph were brother-in-laws, married to sisters, and their families, with children and 3 servants, spent the war years in this tiny 3-bedroom bungalow near Evesham in Worcestershire. And that story is told in Worcestershire as one about them being terrified of a Nazi invasion to London, and as well-known members of the Jewish community, they would be targeted. And one can only imagine the real fear that they experienced. Now, in late November, Samuel reveals himself to be the board of directors and says that he's only going to make the Berkeley into offices, and the rest of the business will carry on, and the management will stay the same. And the board reject his offer because they think he's not going to keep his promise. The Board of Trade report comes out, reveals that Samuel is indeed the raider, that he has 20% of the Savoy shares, that Charles Claw has 9%, and that the Savoy board have only 7%. Claw sells his shares to Samuel, and Samuel then has de facto control. And Savoy's share price rises to 60 shillings. And like two opposing armies, both sides sort of stand back and stare at each other. Samuel stops buying because he thinks that presumably if he converts the Berkeley to offices, 60 shillings per share was the highest price at which he was going to make a profit. And he also presumably thought the board would start to negotiate with him. The board of the Savoy stops buying shares because they've got their defence strategy. And so the share price starts to ease back. On December the 5th, the Savoy shareholders circulate on December the 5th, the Savoy board circulate their shareholders with the Worcester scheme. And as a shareholder, Harold Samuel sees it. It's a complex scheme, but most corporate transactions can be explained in a series of simple steps. The Worcester Building Company is set up to purchase and manage the Berkeley Hotel. The hotel will be sold to them for £30,000, which they would pay for by means of a share swap. The hotel would then be leased back to the Savoy Group for 50 years with covenants that precluded its use as anything other than a hotel. The Savoy would set up a staff benevolent fund which would provide the 30,000 to buy the Berkeley, and the fund's trustees couldn't be dismissed or replaced by the Savoy board. So this Berkeley Hotel is moved beyond any Savoy shareholders' possible control, but also beyond the control of the Savoy board. No one who got control of Savoy shares could get control of the Berkeley. There was no provision for profits to be taken out of the Worcester Company if the Berkeley was returned to profitability. Samuel immediately demanded, as was his right under Section 164 of the Companies Act 1948, a Board of Trade investigation. Finally, the board and the Savoy strike a deal. Samuel withdraws his demand for the Board of Trade investigation. He withdraws his offer to buy the shares. The board buy his shares on an agreed price. His only condition is that Worcester Building Company be liquidated. Now, Samuel actually won the battle of the media, notwithstanding initial concern about the Savoy, a British icon, being possibly taken over and converted into offices. There was huge concern about the Worcester scheme, that it was an action by management that took control of corporate assets permanently away from shareholders to trustees of their own choosing without asking them. And in fact, the Board of Trade eventually appointed an inspector to look into this and to look into the legality of it. And there's a company law point there about exercise of corporate power, and that's not the point that I want to take here, though. I think there are other things of much broader and general interest. In fact, the Savoy in 1955 does manage to create an impregnable structure, which enables it to fight off many subsequent takeover attempts. Trafalgar House tried to take it over in 1970 and came up against this structure. Maxwell Joseph, the same Joseph that Samuel had spent the war with in Badsey, and there he is, tried to take it over on behalf of Grand Metropolitan. He too gave up, sold his shares to the Rothschild Investment Trust, who then sold it on to the Kuwait Investment Office. Finally, in September 1994, the board of the Savoy does agree to sale terms to 40 PLC, a year after the chairman, who had fought off and masterminded the defence against Samuel, Sir Hugh Whatner, died. He was next Lord Mayor of London and clerk to the Royal Kitchens. So why is this of long-term interest? It's of long-term interest, I think, because it is the high watermark era of individual capitalists. People like Charles Claw, Rocco Forti, Jack Cotton, Hugh Fraser, Tiny Rowlands, all of these figures in city development, they filled the pages of Private Eye. They nearly all ended up knighted or ennobled. Harold Samuel became Baron Samuel of Wych Cross, and I've just put up his coat of arms. And this very individualistic structure probably ends with the conviction of the Guinness Four in the late 1980s. No other financial sector in the world was ever structured like this. The attitude of the government towards hostile takeovers actually moderated through the 1950s. It became supportive of the takeover mechanism. So what happened in 1953 with the Savoy set the future shape of the economy really until Thatcher deregulates the city in the late 1980s. Even though the Savoy management was successful in fending that takeover bid off, it marks a big change of heart around how British companies need to be run. It marks the rise of pension funds and other institutional investors. And takeovers are seen as the best way of getting asset value recognised, of getting dividends up and squeezing out poor performance management. So it sees the establishment of the market for corporate control in the UK. UK companies didn't adopt dual class structures in great numbers like they do in the US and on the continent. London Stock Exchange made it clear that in new equity issues that was not going to be possible. The Savoy scheme of 1955 was very much an outlier. Instead, the UK became the most genuine market for corporate control, supportive jurisdiction in the world with extensive protection for minority investors. And what happens in the 1950s ultimately ends up with a city code on takeovers in 1968, which is creates a division between, on the one hand, principles, equal treatment of shareholders by takeover bidders and procedures. We still see the same arguments that the Savoy directors offered to the Board of Trade inspector looking into the Worcester scheme as a defence to takeover mechanisms. So employee welfare, continuity, don't want to be asset stripped. If you look back at the Kraft takeover of Cadbury in the early years of this century, exactly the same sort of mechanisms. I'm right on time. And so thanks for listening. This is Australia signing off.
Thank you very much. So Sally and Vicky, that was really good. And we'll tootle on, Fred, to your paper next. I don't know if you're sharing screen or just talking. Oh, there you are, sharing away. Lovely. So 20 minutes or so, that would be lovely.
Brilliant. So hopefully everyone can see the slides there. Fantastic. Thanks for the thumbs up. Good morning, everyone. And yeah, thank you for a fantastic first paper with a lot of historical detail. I've taken to some extent a slightly similar approach in looking at a couple of specific disputes with a legal angle that occurred within our chosen 1950s decade. But from, in this instance, the perspective of the doctrine of frustration of contracts. So essentially, the way frustration is often sort of taught, and this is sort of, literally taken from having a look at the sort of typical LLB revision guide, is the idea that very basically you've got a long history of contract law not really recognizing any such doctrine, or not in really any major way, and the classic sort of cases like Paradine and Jane, where you've got a literal army turning up on land and that not being enough to frustrate a contract for its use. Then you've got the very famous Taylor and Caldwell, with the concert hall burning down, and a sort of a general agreement that this is the start of the modern doctrine in the 1860s. You've got statutory reform in the 1940s, obviously in large part prompted not just by a perceived general need to reform the law, but the fact that at the time we were obviously involved in World War II, and you've got a lot of contracts being frustrated for particular reasons, such as illegality and trading with the enemy. And then where the 1950s angle really comes in with the fact that a lot of accounts of the frustration doctrine rely very heavily on the comments of the House of Lords, particularly Lord Radcliffe in Davis and Fareham, and I'll come back to that and to the more recent cases as we go along. But I think another way of looking at the doctrine of frustration, by looking at those cases and more, is that up until the 1950s, and in particular the Davis contractors case in 1957, broadly speaking, the history of frustration is a history of the expansion of the law. Obviously, Taylor and Caldwell expanded the law by recognizing. Technically, Taylor and Caldwell was simply sort of carving out a exception to the rule based on absolute contracts. I'm not going to go into great depth about that, but technically could have been considered by the courts to be a relatively minor or relatively restricted exception. But in fact, what we see is really from then on, case by case, the common law really developing the doctrine's application. So you go from Taylor and Caldwell, where the subject matter of the contract was destroyed, through to cases like Jackson and Union Marine, where the subject matter was simply unavailable, through to some of the famous cases, particularly the cases around the cancelled coronation at the dawn of the 20th century, where there is an idea that frustration can be available, where the common purpose of the contract no longer exists, even though the subject matter does exist and is available. And the classic idea of hiring a room to watch the coronation, and the court saying in Krell and Henry that the contract was frustrated because it was not just a contract to hire a room, it was a contract to hire a room with a view. And really, there is very little in the law up to and including the mid-1950s of the courts talking about limiting the doctrine. Mainly the cases are asking, does the doctrine extend to this new situation? Does the doctrine extend to this set of facts, or in this theoretical way? And then there is a really big distinction, really big switch, which I'm going to explore across two cases in particular, from this expansionist view to a much more limited view, which says that essentially thus far and no more, and that frustration pretty much should not develop any further, right through until a couple of recent cases, which were the reason this came to mind. So essentially, I think looking at the law going into the 1950s, there were three questions which still were to be categorically resolved. They were all questions that there was some discussion in the courts in previous cases. They're all arguably questions which are raised by Justice Blackburn's comments back in Taylor and Caldwell. But essentially three questions which I think are distinct, albeit related. So the first question being, what is the basis of the frustration doctrine? Why are the courts recognizing a doctrine of frustration? And really, this is something that judges seem to have a particular interest in. Pretty much every time frustration is considered in the senior courts, at least one judge decides to give a sort of historical sketch and note that there are different juridical bases for the doctrine. And certainly in 1950, I would say it was very much still to be decided what that basis was, what at heart a court considering a question of frustration was legally doing. So you've got generally an approach in the earlier law based on an implied term that, I mean, all of these again can be read out of Justice Blackburn's comments in that sort of case of Taylor and Caldwell. But a lot of cases post Taylor and Caldwell based it very much on an implied term, that essentially there was a term implied into the contract that the contract would cease to exist if, e.g., the subject matter was destroyed, or the common purpose of the contract no longer could be achieved. And that still has support right through. So in Denny Dickinson, 1940s authority in the House of Lords, you've got Lord Porter very much coming out and saying, I think this is the basis of the doctrine. So still got senior judges supporting it going into the 1950s. Don't have time today to go into whether the foundation of the contract not existing anymore is a separate theory or part of the implied term theory, but certainly Peel in the fourth edition of Trital has argued it is a separate theory. Whether it is or it isn't, certainly also involved in some of those speeches. You've got judges like Lord Wright in Denny Mott saying that the heart of frustration is to come to a just solution. So essentially putting it much more as a results-based doctrine, really very much sort of drawing into it applying in a sort of equitable fashion. You've got ideas of construction, that frustration in the end is just a matter of constructing the express terms of the contract and essentially saying whether by constructing those express terms, performance essentially becomes impossible through no fault of the parties. And you've also got this sort of related doctrine of total failure of consideration, which was sort of particularly raised in the very individual case of Fibrosa Spolka, to some extent not required post 1943 because of the statutory reform, much more based on the outcomes once a contract was frustrated and what would happen to monies paid and payable. but certainly still in the mix at this stage. By 1960, we've got pretty much a unanimous decision that construction is the basis of the doctrine. So that's the first sort of thing that's established through the 1950s. Arguably, though, it doesn't matter. And I've quoted Professor Peel here, who's taken on Treitel's work on frustration, that arguably there is no practical importance to what the theoretical basis is, because in all of these cases, asking why the court might find a contract to be frustrated is interesting, but it doesn't actually really answer the question of whether the contract has been frustrated. And so to some extent, I think that there are other questions that needed to be resolved, and that's one of the things the courts noticed in the 50s. And so that's what brings me on to where I sort of want to focus for the rest of the presentation, which is the next question which the courts had to address was, is there a general discretion to discharge contracts? Does frustration essentially have arguably no particular coherent principled limit? Can the court basically engage frustration as required? And this brings me on to the first case I want to look at in some detail, which is British Movietone News and the Pavilion Theatre. So this is a case involving distributors of newsreels who were distributing them to cinemas around the country during the Second World War. Obviously, huge appetite for newsreels at the time, people wanting to see and hear about what was happening in the conflict. And so contracts made in 1941 between the distributors and the owners of this particular cinema in Aylesbury to supply them with newsreels for a set price. In the 1940s, in 1943, the government introduces an order which rations how much film can be used, because there is an increasing military need for film to be used for things like filming bombing raids on Germany. So what happens is that the distributors, British Movietone News, agree with their various recipients that they will provide less newsreels and that they'll be shared by different customers within a geographic area. So in particular, that these newsreels would go to Aylesbury and they would essentially get one newsreel between more than one cinema, and they would pass the newsreel back and forth between each other to show it. And in order to do this, and this is the contractual issue, they make a supplemental agreement which states, while the 1943 order is in force, these terms will apply. After the war ends, the order is not ever officially repealed. Other law is made to negate it, but it still remains on the books. And so when the defendants, who now don't want to show newsreels because the war's over and they don't think there's an appetite anymore for newsreel content, when they try to end the agreement, the distributors say you can't end the agreement because essentially we have this express wording that it can't be ended while the 1943 order is in force. And the matter ends up being argued to the Court of Appeal on the grounds of, arguably on the grounds of frustration. We'll see in a moment why I say arguably, after Justice Slade at first instance held that the agreement was binding. So it comes to the Court of Appeal, it comes to Lord Justice Denning giving the judgment. And the judgment starts pretty much as many of these frustration judgments do, talking about the different sort of grounds on which contracts might be frustrated. And Lord Justice Denning points out that from the arguments of counsel, you could try to claim the agreement didn't apply through its construction, through an implied term, or through something analogous to frustration. So sort of putting those bases of frustration slightly differently, but so far still pretty much in line with what we'd seen up for grabs. But then what you end up with is Lord Justice Denning building on that in a rather Denning-esque way and saying, well, we're looking at the intention of the parties, we're looking at these issues around constructing the contract, implying terms. Really, though, in the end, what we can do is say the words do not apply because the parties did not contemplate such a surprising turn of events. And this is essentially adding something very new to frustration. And going on to say, the court has this qualifying power in order to do what is just and reasonable in the new situation. So essentially saying, in the end, the court can make up frustration as it goes along. This is rather witheringly dealt with in the inevitable appeal to the Lords. Viscount Simon saying that the comments of Lord Justice Denning would require careful and candid consideration. And that careful and candid consideration is pretty negative. Note, Viscount Simon does start very much on an implied terms basis, talking about the famous officious bystander test, and then goes on to the fact that while the theoretical basis for the rule does not really matter, so again, the court mentioning it, but saying it's perhaps not the most important question, the idea that an uncontemplated turn of events is enough is essentially not part of the law and appears to be likely to lead to some misunderstanding, to put it mildly. So essentially what the Movietone news case tells us is pretty categorically, frustration doesn't involve a general discretion. What we then get in Davis and Fareham, where you've got contractors basically underbidding for work to build houses and then trying to claim the contract was frustrated to open up the chance for a quantum merit payment. You've got the House of Lords then having to say, okay, well, we've established what the basis is not. What is the actual test for frustration? What line are we going to draw? 4 of the 5 Lords spoke directly on this point. And it's really interesting to see here, even in 1956, even in the case which is basically decided now in the law books as this is the modern doctrine set out, still disagreement. Viscount Simmons saying there was no need to talk about the juridical basis. Lord Morton still talking about implications in the contract, still using the language of implied terms. Lord Reed openly saying that it probably wouldn't normally, in most cases, involve implied terms, but construction of the contract. Different talks about what, different comments that they then go on to say. The laws go on to say about these bases. Viscount Simmons saying, keep the doctrine within narrow limits. Lord Morton saying that perhaps the test should essentially be that you can set a particular date for frustration. And Lord Reed saying, using language from a previous decision of Lord Justice Asquith, about whether the change in circumstances is fundamental enough, fundamentally different. And so it's interesting that what has been seized on ever since is none of those judgments. It's that of Lord Radcliffe, and in particular, this very famous line of, after saying basically that the implied term test should be laid to rest, that circumstances in which performance is called for would render it a thing radically different from that undertaken by the contract. What that means is that from 1950, where we weren't sure what the basis is, by the end of the decade, we know that the basis is how the contract is constructed. To go back to Lord Radcliffe's words, that which was undertaken by the contract. We now know the limits. We know that the court cannot simply impose frustration on the basis it is just. And we now have this language of radical difference, which really constrains what judges can do, because unless they can point to a radical difference in what performance would now entail compared to the original contract, there can't be frustration. And what I think underneath has really happened, if you put all of those together, is that what was very much at least partly subjective approach that looked very much at the parties and what was just given what the parties had promised to do and wanted to do, is replaced with this much more objective approach, which absolutely prioritizes the express terms of the contract above everything else. And I think what that leads to are some interesting questions, and this is work in progress really, but just to sort of close on, does the development of frustration show a trend of commercial certainty? So is this all about establishing commercial certainty? Is this a reaction to historic events? It's been argued that, you know, the courts in the First World War in particular were very willing to use frustration as a very practical tool to settle disputes caused by a pretty unprecedented armed conflict. By World War II, you see the courts starting to be a lot less willing to use frustration in some instances. And very interesting that in the same year, you've got the Suez crisis, the closure of the Suez Canal, and a real move as a result of that toward force majeure clauses and away from frustration as a doctrine, because frustration doesn't normally have space to operate if the contract has a clause relating to force majeure. What's very interesting is in recent cases, and in particular, the case on the European Medicines Agency and trying to say that their lease in London was frustrated as a result of Brexit, applying the test from the Sea Angel, that test talks about taking into account the demands of justice. And in the EMA case, Justice Marcus Smith literally said that one of the relevant factors was the parties' declarations of their subjective intent. And it's interesting that perhaps something which seems to have been settled for 70 years may just be being reopened. And given COVID, Brexit, and of course the unintentional closing of the Suez Canal last year, it's worth wondering what might be in the pipeline, given the number of cases we're likely to see on these issues coming through into the appeal courts over the next few years. So perhaps we might need to revisit those 1950s cases again. And that's me. I'm afraid I wasn't as perfectly on with 20 minutes as before, but I will finish there.
Thank you very much, Fred. Okay, so we'll hopefully move seamlessly on once you stop sharing your screen, or whoever's sharing it stops sharing it. Lovely. And Rachel, hello.
Sorry, Fiona, I think I shared a little too early. So let me just try sharing it again. And how's that? Everybody can see that?
Yes.
Excellent. Well, thank you very much. I just want to thank you very much, Fiona, and also Rosemary for building the field. It's a classic example of build a field and they will come. So thank you very much for that opportunity to contribute to this collection of the 50s cases. And I've been fascinated by the previous two papers, and this is taking a different tack. This is a tort law examination of what I think is one of the most important cases of tort law, that of Bolton and Stone, a case with which we're probably quite familiar, but the ramifications of it, both judicially and in the legislature, have been quite interesting over the years. So my title is Escaping Breach via Bolton and Stone, what could or does statute add 55 years later via the Compensation Act of 2006. So in my talk, I'm going to divide it into 3 sections. First of all, I'm going to consider the impact of Wolfenden Stone. Secondly, I'm going to look at Section 1 of the Compensation Act 2006. And thirdly, I'm going to just have a look at what the judges have made of Section 1. Now, just to revise, we're all very familiar with this, but the particular element that Wolfenden Stone has impact upon is the second of the elements of the tort of negligence, and that is whether the cricket club committed a breach of their duty of care to Bessie Stone. So in relation to the first section, it was indeed, as I've mentioned, cricket at its finest. This case arose out of a mishap at a cricket ground in Manchester. Bessie Stone was standing outside a residence in Beckenham Road, and she was struck by a cricket ball. And this was a 6. It was only around the 6th time that this had happened in 30 years, according to the evidence. The ball had travelled some almost 100 yards. It had surmounted a fence, and that fence was, although only 7 foot high, it was 17 foot high if you took account of the slope of the ground. So it was a massive hit Miss Stone and caused her physical injury. So Miss Stone sued the cricket club both in nuisance and in negligence. And in fact, the case had quite a turbulent ride. In relation to first instance, Justice Oliver rejected both claims in nuisance and in negligence. But when it got to the Court of Appeal, the Court of Appeal agreed with Justice Oliver that nuisance was not made out, but accepted that negligence was. And hence it was the cricket club that took the case up to the House of Lords, and the House of Lords said that at that point nuisance had been abandoned, and that on the point of negligence, the claim of negligence, there should be no finding adverse to the cricket club, i.e. no negligence. Now, this case really is as a standout. 1951, very early in this decade, but it's a standout for 2 legal propositions which have become more and more honed over the intervening years. The reason that the Court of Appeal and the House of Lords split and differed in their verdict on this was the test of foreseeability. Now, as I said, the evidence was that this had happened some 6 times in 28 years. The evidence confirmed that, although the cricket club had been in operation for around about 90 years at the time of this incident, but there'd been these sorts of hits periodically, but rarely. But according to the evidence, nobody had actually been struck by such a ball, but the ball had exited the ground. Now, the Court of Appeal thought that because it was a foreseeable event that this could happen, then a reasonable cricket club would take measures in response to that risk, so as to exercise reasonable care to take precautions to avoid injury to people such as Miss Stone. Now, the House of Lords disagreed and said that the test was that of reasonable foreseeability, not of foreseeability. And they did not consider that the juxtaposition of circumstances, and that is the rare incident of such a large hit, plus the fact that somebody would be hit in what was a relatively sparsely populated area. The House of Lords thought that the test of reasonable foreseeability was not met. And hence, on that basis, the cricket club defeated the claim in negligence. But in the course of the judgments, which there were a number of separate judgments, there was, although it wasn't stated to be a quadrant of factors of this sort, one can pick out from the judgments why the law lords further thought that there should be no negligence found. And that is that the precautionary steps that Miss Stone was putting to the court that ought to have been done by a reasonable cricket club were not necessary. Now, why were they not necessary? The probability of the injury was just too low, 6 times in 28 years. The gravity of the injury might have been reasonably high, but if struck, but the cost of the implementation of these precautionary steps was too high for a cricket club of this sort, and the social utility of what the cricket club offered to the community and to travelling teams, etc., would be highly compromised if the precautionary steps were put in place. Now, what precautionary steps did Miss Stone wish the cricket club to exercise as a reasonable cricket club? She wanted them to erect a higher fence. It was 7 foot around the perimeter, but as I say, at the point at which it sailed over the fence, 17 foot above the pitch. She suggested that the pitch should be moved to further away from the northern boundary, and there was a third open-ended pleading. That is, that the cricket club should take whatever other measures are necessary to prevent harm to someone in her position. And so Lord Reid said, well, surely it can't mean that they stop play at the ground altogether, can it? And by his own rhetorical question, it's answered that no. Now, in that respect, as I say, the quadrant of factors has become quite formalised in the analysis of negligence, and it wasn't so in Bolton and Stone. It wasn't, but those particular factors are very evident across the individual judgments. And having considered what Miss Stone was requesting a reasonable cricket club to do, and then deciding that by virtue of this quadrant of factors, a reasonable cricket club was not required to do that, then there was no breach. Now, the view in Bolton and Stone that precautionary steps have to be judged against these sort of factors, how probable was the injury, how costly would they be to implement, etc. That was honed over the course of intervening judgments, but probably no better illustrated than John Tomlinson. Now, this, of course, was some 50 years later, but John Tomlinson, 18 years old, visited a picnic park and had a nice picnic, decided to go for a bit of a dip in the lake. It was a disused quarry which had been flooded, decided to go for a bit of a dip, and he decided to take a running dive in the lake. It was murky water, and of course he was up to it in about knee deep. But he took the dive and he hit his head, and he was rendered a tetraplegic as a result. Now, he sued the occupier of the picnic facility, Coglinton Borough Council. Now, again, the classic sort of negligence scenario. What should a reasonable occupier have done differently? And he suggested three things: more lifeguards, more signage, and ripping up the beach so that access to the lake was not permissible, was not practicable. And again, the House of Lords considered and referred back to the Bolton and Stone judgment. And by this point, the analysis of these four factors in the quadrant were becoming much more de rigueur, if you like, much more common in the first instance judgments as well as on appeal. Now, again, the probability of the injury happening of this sort was low. It was tragic that it happened, but it was low. But their plan or the suggestion to rip up the beach was absolutely inimical to the task of a picnic facility offered by the Coglinton Borough Council, said Lord Hoffman. Most people, most of the time, approached it in the correct manner, i.e. that they paddled in the shadows, but that there was no swimming. They obeyed the signs which were liberally around the perimeter of the lake, which said no swimming. And so it was considered that this one particularly, the ripping up the beach, would be a high compromise and an unnecessary compromise to the recreational facilities that were offered by the Coglinton Borough Council by virtue of this facility. So and in relation to the Tomlinson judgment, I particularly noted Lord Hoffman's extracts, but he's harking back to Bolton and Stone, and he's saying that in relation to the accidents that occur in life, they do, but there has to be a balance struck. And this was the view that was very plainly put in Bolton and Stone, carried throughout the jurisprudence. But Lord Hoffman's reiterating that the House of Lords held it was not negligent for a cricket club to do nothing about the risk of someone being injured by a cricket ball. The cricket club were carrying on a socially useful activity and would have had to stop playing cricket at that ground. It was also part of the evidence that erecting a higher fence or moving the pitch was beyond the scope of their financial resources. And had they had to do that, then the cricket club would have ceased to exist. And so he says it's a kind of balance that has to be struck. And it may lead to the conclusion that even if injury is foreseeable, which it was in John Tomlinson's case, and Lord Hoffman makes the point in this passage that it was a foreseeable injury to Miss Stone, but of course, as I said, the House of Lords said it wasn't reasonably foreseeable. Lord Hoffman goes on to say that it is still in all the circumstances reasonable to do nothing about the risk that is posed. And it's very much, part of what we as lawyers know, that just because there's an accident does not mean there's any liability, does not mean that there's anybody at the end of the day who's going to pay any compensation for what is, in John Tomlinson's case, an extremely serious injury. So one would have thought that would have been it, but it wasn't, because in 2006, Parliament enacted Section 1 of the Compensation Act. Now it's headed the deterrent effect of potential liability. And it states that a court considering a claim in negligence, which I'll concentrate on for the purposes of this presentation, may, underlining may, a discretionary terms, not mandatory, in determining whether a defendant should have taken particular steps to meet a standard of care, whether by taking precautions against risk or otherwise, have regard to whether a requirement to take those steps might prevent a desirable activity from being undertaken at all, or discourage persons from undertaking functions in connection with a desirable activity. So Section 1, it provides a discretion vested in the court that they may take account of whether implementing precautionary steps would prevent a desirable activity from being undertaken or discourage people from undertaking functions in connection with those. Now, that sounds very, very similar to what was or is the fourth quadrant of the Bolton and Stone analysis, which then, of course, became hugely important in John Tomlinson's case, and indeed was one of the key reasons why John Tomlinson, with his tetraplegic injury, was unable to recover any compensation at all. It was that element, that part of the breach analysis, which was really very adverse to any finding in his favour. So, why implement Section 1? Now, the explanatory notes to the Act when it was published said that really it had its twofold effect. It was meant to improve awareness and on the fact that there was no compensation culture in this country, to provide reassurance to people and organisations who are concerned about possible litigation, and to ensure that normal activities are not prevented because of fear of litigation. And then the drafters of the memorandum went on to say that it's not concerned with the standard of care, it's not concerned with when a duty of care is to be owed, it's solely concerned with the court's assessment of breach. Well, when it was going through as the compensation bill, it generated quite a lot of controversy, and the Right Honourable Bridget Prentice, who was the promulgator of this particular bill at the time, Parliamentary Under Secretary of Constitutional Affairs, she was forced to defend the section in quite strong terms under some quite vociferous criticism by other MPs. Now, I've drawn this particularly from the debate on the 8th of June at these particular columns. And she notes that members had concerns about the need for what was then Clause 1, but we believe it's important and that it will have benefits. Although a compensation culture does not exist in this country, the perception that it does can have a real and damaging effect on people's behaviour. And then she goes on to say that Volunteering England had done a study and found that nearly 1 in 5 organisations said that people had stopped volunteering for them because of fears about the risk of being sued. And nearly a quarter of organisations said volunteers have been deterred from joining them in the first place. And she says that these fears may well be out of proportion and based on inaccurate perceptions, but they're very real. So Clause 1 is meant to assuage those sorts of concerns. Now, she then goes on to consider the very case of Tomlinson and Coglington. And she says that the views have been expressed to me that the ruling in Tomlinson and Coglington is part of the law, and it's reflected in Clause 1. And she said that, of course, that may be the case, but the clause will nevertheless have a range of benefits. It is there for reassurance. Now, what were these criticisms raised by other members of Parliament? I've just drawn these from the same date this is where the principal debate on the compensation bill occurred in the Commons, and a number of criticisms were put forward. Does this change the law in that would-be defendants need to put together a risk assessment before any activity for which it is considered that there would be some prospect of litigation? Now, that's not what the law requires now, and it wasn't at the time, but would that be mandatory in order to defeat a finding of negligence if one was a defendant? What does a desirable activity? Unhelpfully, it of course wasn't defined by the Compensation Act, and it was raised as to how Section 1 applies to an asymmetric relationship, that is where the power and the bargaining position may be vested more in one party than the other, and the employment relationship being given as such an example. So would an employer be able to escape liability when sued in negligence because the employer was engaged in a desirable activity? That question was raised in Parliament. Furthermore, but what about those working in the emergency services and A and E units? They are engaged in what is generally considered the public good. That is a desirable activity in the colloquial speak, and surely would fit within the province of Clause 1. And so the question is raised as to whether in those circumstances, would they ever be able to bring a civil suit in negligence? Because surely whatever defendant they were suing, that they would be engaged in the provision of a desirable service, a desirable activity. So would it actually harm the chances of some persons bringing actions at all? It was also asked, what is this? An attempt to start codifying the law of tort? And to that, the Right Honourable member answered that we, as most governments have in mind, would like to codify the law, but this is not the aim of this particular provision. It's simply to reassure and to clarify the law. So that very statement that we, as most governments, would like to codify the law, I'm sure would be a great surprise to most judges, particularly in black letter subjects of the sort that we have been considering today. And furthermore, the rather dismissive statement was made, well, look, if this is an attempt to clarify the law, it can't be done in a single sentence, can it? So there were quite vociferous criticisms of this, but nevertheless, it went through and it stands on the statute books as Section 1 of the Compensation Act. So what I've done is, for the purpose of this presentation, is just gone through the case law which has considered Section 1 and what impact has it had on real life tort litigation. Now, it is quite clear that the judges are split in this country as to whether Section 1 does anything at all. Now, in this case of Goldschneider and Royal Opera House concerned a claim in negligence brought by a trumpet player who alleged a sudden and career-ending loss of hearing when participating in rehearsals for a Wagner opera. And that trumpet player sued the Royal Opera House Garden Foundation in negligence. Now, the orchestral activities were agreed by the parties to be desirable activities. But what was the impact of Section 1? Now, on appeal, it was said that whether or not Section 1 alters the common law, as laid down in Tomlinson, we do not consider that it assists the defendant, in this case, the Royal Opera House. And in fact, in that case, there was a finding of breach. But at first instance, Justice Nicola Davies had actually said quite categorically that the provisions of Section 1 add nothing to the pre-existing law. And indeed, in the case of Wilkinshaw and Fuller some years previously, Justice Owen said that if all Section 1 does is to reflect the existing law, which is what the explanatory memorandum says, then it's somewhat difficult to see why it was felt necessary to enact it at all. And it's certainly quite difficult to see why it was couched in discretionary terms. Now, both Bolton, Stone and Tomlinson, both of those judgments very much turned upon the analysis as to whether the cricket club was providing a socially useful activity. And of course, in the Tomlinson's case, the Coglington's provision of picnic facilities was very much at the heart of the breach analysis. And indeed, had those courts not considered that, certainly Bolton and Stone probably, was setting the law, it was a very evolutionary stage. But had Tomlinson not considered that aspect of the breach analysis, that particular fourth quadrant, that would have been a grave error of law. And so Justice Owen is making the point that Section 1 is quite wrong, because it is not a discretionary factor under breach analysis at all. It's a compulsory factor, and that stems from the 1950s case of Bolton and Stone. So as we can see them from the judicial discussion of this, the judges in this case, 2019, the judges even some 13 years after its enactment, they still can't agree among themselves as to whether Section 1 actually does anything. Now, what would it do if it amended the substantive law? Now, in addition, or perhaps more realistically than some of these concerns raised by the MPs, one would wonder whether for those defendants who were engaged in desirable activities, it would be often a case whereby the claimant could not establish negligence because the fourth quadrant was assuming a much greater importance than it typically does. Now, of course, it did in Tomlinson and Bolton, but there are other cases, many other cases, in which that fourth quadrant, whilst the desirable activity is undertaken by the defendant, there are other factors which trump that, such as if there's easily and cheaply implemented precautionary steps that could have been done to prevent the harm from occurring, then typically that third factor will trump any social utility that the defendant offers. So in that respect, did Section 1 sort of bring that fourth quadrant to the fore, such that it would be very difficult to establish a claim of negligence against a defendant who was engaged in a desirable activity? Now, the review of the case law shows that that concern has not been borne out. Now, this is the case law which has considered Section 1 since its enactment. For one thing, you can see that it's not been considered that often. I mean, for an area which is highly litigated under tort of negligence, and particularly also under the Occupiers Liability Acts, it's not a section which has received a lot of attention. Now, I've divided it into three categories. Cases of negligence where Section 1 was simply said not to have any application at all. And that was obviously true in the case of Primavera because it concerned planning permissions. But there are cases where Section 1 has been simply mentioned, and there's been absolutely no discussion at all as to what impact it might have upon that particular litigation, that claim in negligence. And some of these claims, Shelbourne was absolutely accepted that Christmas parties, work functions, they do have a desirable function in bonding and in morale. So that was a desirable activity in holding the Christmas party. But having stated Section 1, there was absolutely no discussion about it at all. Now, in relation to where Section 1 is at least given some scant regard, these are the cases which are identified from the case law databases. And you can see that from the outcomes, it's split very evenly. There is absolutely no suggestion from the outcome of these cases that Section 1 is having an undue influence on the analysis of breach. By no means. Furthermore, there has been no detailed judicial discussion in any of these cases as to what Section 1's impact is upon the Bolton and Stone and Tomlinson jurisprudence. And there is a split amongst the judges as to some say it adds nothing to the common law, and that's the end of the discussion of Section 1. Some say, as the Court of Appeal did in Goldschneider, whether or not it adds anything to the common law, it doesn't assist the defendant in this case. There's been no detailed consideration of the interplay between Section 1 and the common law of breach. So in that regard, it's surprising, and I must say, it irritates me. It's one of my personal beefs about legislation that is put forward for no reason at all. Legislation which has the danger of amending the common law, and was simply promulgated supposedly to clarify the common law, but may have unintended consequences. Now, I think my conclusion, at least on the analysis of Section 1 for the purposes of this presentation, is that the unintended consequences concern has not been borne out by Section 1. It has not amended the common law set out in Bolton and Stone and in Tomlinson in any way. It's not saved every defendant who is engaged in desirable activities. Indeed, many of these defendants have been found liable in negligence because of the failure to implement precautionary steps which were cheap or easily implemented, which did not require a lot of resources on their part, or indeed where the gravity of the injury to the claimant was immense and where the probability of the injury was relatively high. In those circumstances, negligence has been found against defendants, even where they were engaged in desirable activities by either the court's judgment or the defendant's own admission. So the overall impact of Section 1 has been, I think, pretty non-existent. It hasn't saved defendants. It hasn't brought out the fourth quadrant in any particularly significant way, and hence my conclusion, it was an unnecessary provision to enact. I think it is dangerous I really think it is dangerous where governments seek to have a go at clarifying the law and reassuring the general public. I mean, the common law is a precise thing. Of course, it's built up by a body of precedent, but it is a relatively precise thing. One knows the principles that have to be brought into the arena in order to establish whether there's a cause of that negligence or not. These are developed carefully over the course of case law. And I think these sorts of provisions as exist in Section 1 are very unhelpful at best. They could be dangerous at worst, but this particular one, I think the conclusion is it's not dangerous. So I hope that that's been of interest. I think the sooner that they really strike Section 1 off the statute books, really the better for us all. Thank you.
Thank you very much, Rachel.
So, Caroline, do you want to start?
Yeah, so I'm looking at the Wolfenden Report, and basically, so in 1957, the Committee on Homosexual Offences and Prostitution, better known as the Wolfenden Committee, published its report. And the Wolfenden Report is perhaps one of the best known legal developments of the forgotten decade, the 1950s, because it marked a key shift in the regulation of both male homosexual acts and prostitution. And I'm going to be concentrating on the part of the report concerning homosexual offences in order to argue that it had significant implications not only for sexual acts between men, but for the law on sexual offences more generally. And in doing so, I'm following a number of other critics, but I go on to argue that there's another aspect of it which is rather less well known, namely that it also marked a key shift in the legal regulation of sex between women. So when Wolfenden reported, the legal landscape for sexual offences was highly gendered and highly discriminatory. Sex between men was completely illegal, whatever form it took. Sex between a man and a woman or two women was legal, provided there was consent, and that consent was only legally valid if given by a person over 16. Within that general rule, there were various subtleties. I won't go into detail, but basically penis and vagina sex was given special status in terms of both factual consent and age of consent through the offences of rape and unlawful sexual intercourse, respectively. And that wasn't, I'd say, just about the relative seriousness of the offence in terms of harm and so on, but very much part of a highly normative idea around what sort of legitimate and moral sexuality was. Sex between women was regulated not only by indecent assault and also use of some other offences like breach of the peace, but also by a determined legal silencing of its possibility. And this was a centuries-old approach, but it really reached its apogee under the Victorians. And when I talk in a second about the model of sexuality it is based on, it becomes obvious why. But it hasn't disappeared since, and it was certainly alive and well in the 1950s. And the idea that you could silence lesbianism, that you could not talk about it and that would stop it happening, depended upon a sharp differentiation between active, desiring masculine sexuality and submissive, undesiring female sexuality. Put simply, sex was something men wanted and asked for, and women didn't particularly want but submitted to. That model obviously left very little space for women to discover lesbianism for themselves. If they're passive, how are they going to approach another woman? If they're not really desiring, why would they bother? But it did make criminalisation a dangerous source of publicity for this forbidden knowledge. So it was assumed, tacitly said, and sometimes expressly articulated that basically, if it were a criminal offence, then the fact of the offence, let alone the fact of a trial, would publicise it. And then there was the risk that women knowing about it would be curious and try it. And as various parliamentarians had actually spelled out back in 1921, when this was debated, if women tried it, they thought that they would probably never go back to their husbands again. So there was very real fear of lesbianism. Sometimes it's assumed the sex between women wasn't criminalised because they thought it was okay. It wasn't, it was a real anxiety, but because of this sharply differentiated model of male and female sexuality, keeping it quiet seemed the best way to keep it out of the knowledge, certainly of respectable women, their own wives and daughters. There had been some apparent cracks in the wall of silence in the 1920s, the parliamentary debate I mentioned, the obscenity proceedings against the lesbian novel, The Well of Loneliness. But courts and legislators and Parliament had been quick to reinforce silencing, and that policy was still standing in the 1950s, although under increasing sort of pressure. The sort of sexological developments, the knowledge of homosexuality that had meant it became a bit visible in the 1920s were sort of filtering through into wider consciousness and starting to push against it in the 50s as well. So, as is very well known, the Wolfenden Report's main recommendation in relation to homosexual offences was partial decriminalisation of sex between men. And popular interpretation of this is that it was a liberatory moment, a sort of harbinger of the swinging 60s, the start of the law's liberal approach to sexual offences. And yes, it did help to end a history, that long legal history of complete prohibition of male homosexual acts. And it did base its recommendations in part on the liberal harm principle, which has become the guiding principle, not entirely evenly, but the guiding principle for sexual offences today. So in that sense, it was the starting point of legal liberalisation, which culminated arguably in the Sexual Offences Act 2003 with its commitment to non-discrimination. However, the full picture is a more complex one. Critics including Geoffrey Weeks, Leslie Moran, Justin Bengry, Harry Cox have explored this, particularly in relation to sex between men. The first point to make is that the report itself introduced the terminology of homosexuality and homosexual acts into the law and the legislative discussion. Second, Wolfenden's recommendation was for a cautious decriminalisation, whose version of the harm principle hardly amounted to a ringing endorsement of gay liberation. It was rephrased at various points in the report. The key one is there must be a realm of private morality and immorality, which is, in brief and crude terms, not the law's business. So homosexuality was still characterised essentially as immoral. And the proposed relaxation of the law was highly constrained in its scope and hedged around with justifications, aiming to allow homosexuality to be treated and contained rather than to proliferate. Accordingly, the version of the harm principle itself was highly qualified. The criminal law, the report said, could intervene to preserve public order and decency, and should protect the citizen from what is offensive or injurious. And that conceptualization of offence as a relevant harm pervaded the recommendations. In common with Wolfenden's proposals on prostitution, this part of the report aimed to keep what was immoral or offensive out of sight. So the consequence was that acts were only to be decriminalised if performed in private, a limitation enthusiastically embraced by future legislators and courts, and the private was exceptionally narrowly defined, effectively limited to a situation where only two men were present, and there was no real prospect of their being joined or observed by anyone else. Another way decriminalisation was intended to keep homosexuality literally out of sight was through avoiding high-profile prosecutions, such as the convictions of actor John Gielgud in 1953 and of Lord Montague of Bewley, his cousin Michael Pitt Rivers, and the diplomatic journalist Peter Wildblood in the following year. So the Wolfenden basically said, if this isn't an offence, we can quietly ignore it rather than having it in the newspapers, which had been a major provoking factor of the committee in the first place. So this emphasis upon decriminalisation as containing rather than liberating gay men was in part given a medical rationale. That was probably largely strategic. There was certainly no consensus on key medical features of homosexuality, such as its causes or curability. Nonetheless, medical evidence was used, not only to suggest that decriminalisation would encourage gay men to seek treatment, but also to justify imposing an age of consent of 21, substantially higher than the age of 16 for other sexual activity. And again, this differential age of consent was embraced by parliamentarians, and indeed a higher age remained part of the law, actively supported by a significant proportion of MPs and peers until equalisation of the age in 2000. So Wolfenden then shaped the law on sex between men for the remainder of the century, although only after a slow start. The legislation implementing the Wolfenden Committee's recommendations took a decade to be passed. The Sexual Offences Act 1967 largely reflected the report's proposals, and although it was amended in the 1990s to lower and eventually equalise the age of consent, it remained in force for the remainder of the century. So Wolfenden's aftermath in this context was something of a mixed one. Although some sexual activity between men was decriminalised, the limitations suggested by the report and then enshrined in law had lasting effects. First, practical limitations, the very partial nature of decriminalisation, left men engaging in sex with each other still vulnerable to prosecution, and indeed the police were enthusiastic to show that this was only partial, and so the number of convictions actually rose after the Act became law. Second, the reforms were founded upon and therefore reinforced a rationale of fundamental inequality, which entrenched the presumed inferiority of homosexual acts to heterosexual ones. And as we'll see, that was achieved in ways which also had significant consequences for the regulation of sex between women. And that might seem a surprising claim because female homosexuality is barely mentioned in the report. A brief reference to convictions of women for indecently assaulting females suggests that they are less, quote, libidinous in nature than men's offences. And there is something of an explanation for this. It says, due in the main to the practice of including in the figures relating to any particular offence, not only those convicted of the offence itself, but also those convicted of aiding and abetting the commission of the offence. So that was a reference to most convictions of women being based on liability as accessories to men's sexual acts. But it left the impression that women lacked much in the way of sexual agency or desire. As almost the only mention of lesbianism, its association with the less libidinous was significant. Despite the report's implication that a minority of cases did involve women as principal offenders, nothing more was said about them. So in consequence, the law on same-sex activity between women remained unchanged, which is to say there was no specific prohibition, but it was governed by other provisions, including the law on indecent assault, as well as the repressive socio-legal effects of silencing. However, the committee's proceedings show that the report's dismissal and subsequent silence were neither inadvertent omissions nor due to genuine lack of interest or evidence. Those proceedings, in which they heard evidence from a wide range and large number of witnesses, were held in private because Wolfenden was a departmental committee rather than a royal commission. So while the evidence survives in the National Archives, the report has entered public consciousness uncomplicated by the rather different story told during the proceedings which informed it. And actually, the committee felt from the outset that sex between women was within its remit, and it explicitly included indecent assault of a female in its list of homosexual offences. That decision and its consequences were a crucial moment in the regulation of lesbianism, because for the first time, it was being officially treated as parallel to male homosexuality. So this connection is being made, homosexuality as a single phenomenon, albeit with male and female versions. The prevalence, nature, and legal position of lesbianism were repeatedly raised in the evidence hearings, either by the committee questioning witnesses or by witnesses themselves. It is then a theme that runs through much of the evidence before the committee, and two key aspects are apparent. First, the committee members were keen to ask professional witnesses, particularly doctors, psychiatrists, criminal justice professionals, about how prevalent they thought lesbianism was and how it compared in its nature and effects to male homosexuality. And the underlying concern was whether they could get the evidence to sufficiently distinguish it from male homosexuality to justify its very different legal position. Secondly, witnesses themselves frequently spoke about it in order to invoke the unfairness of men's and women's different legal positions. And both the very few openly homosexual witnesses and many of the experts, the professionals who worked with gay men, frequently said this inequality between men and women was keenly felt and was a barrier and a cause of resentment, because basically gay men were being told what you're doing is wholly illegal and immoral, you ought to change your ways, and they're saying, well, you're not saying that to women. Committee members were not very sympathetic within the hearings to this argument. They tended to respond by pointing out that, well, if you want equality, we could just criminalise sex between women. It wouldn't necessarily lead to decriminalisation for men. So be quiet, basically. And that rejection of equality as a rationale for reform was crucial to the report's approach. In large part, that did make political sense. Even the much more conservative basis upon which reforms were proposed took a decade to win parliamentary acceptance. However, if homosexuality's inferiority to heterosexuality was accepted by many reformers as well as parliamentarians, the different laws for men and women did still need some justification. And the committee's efforts to find it in clear, relevant differences between male and female homosexuals were not terribly successful. Witnesses differed widely on these points. There was no consensus that sex between women was either less prevalent or less socially harmful than sex between men. So the report instead evaded the issue by dismissing and silencing sex between women, an approach that obviously chimed somewhat with the wider legal strategies already in place. So the Wolfenden Report then acknowledged the existence of lesbianism, but immediately dismissed its significance and sexual nature. Thus, lesbianism became briefly visible, simply to be rendered invisible again. And this dismissal of women was essential to achieving partial decriminalisation for men, because it allowed the report to evade questions of equality, which would have suggested more radical and thus politically unacceptable answers. So Wolfenden therefore executed a sort of double manoeuvre, tying lesbianism to male homosexuality, which hadn't been the previous legal position, while simultaneously differentiating it as a less troublesome, less sexual sort of homosexuality than the male variety. The consequences of women being silenced in this way have persisted long past the Wolfenden Report's direct influence. Discussions of sexual offences law have continued to focus upon sex between men, while sex between women is treated as a milder version of it that can basically follow the same approach, or has been simply ignored. And that can be dangerous. For example, there has been an age of consent for sex between women since 1880. It has been 16 since 1922. However, the myth that there is no criminal law and therefore no age of consent for lesbians persisted into the 21st century, including in some apparently authoritative sources. Young women were thus unknowingly exposed to the risk of prosecution. A 16-year-old with a 15-year-old girlfriend would think that she was doing nothing wrong. In fact, she would be committing a criminal offence every time they did so much as kiss. And that risk of prosecution was by no means hypothetical. There were indeed prosecutions and convictions. It was only in the latter stages of the campaign to lower the age of consent for sex between men, when equality became a dominant and achievable aim, that the existence of a lesbian age of consent began to be implied and occasionally mentioned expressly, because it fell within the 16 for everyone approach, rather than because it got any consideration in its own right. And that carried on with the passage of the Sexual Offences Act 2003. It involved very little consideration of sex between women, with consequences that the position of women was pretty much ignored, and had some effects that were perhaps not obvious. For example, the first set of sentencing guidelines based the seriousness and thus suggested sentence very mechanically on exactly what type of sexual touching was involved, in ways which resulted in significantly higher sentences being suggested for sexual activity between women than had been the case in recent cases, with some exceptions. Or that really sort of worked on the facts. These guidelines just didn't really work for women and worked very negatively for sex between women. And the lack of explicit discussion of lesbian equality has also left some judges, feeling able to treat lesbian desire as a problem when faced with it in the courtroom. So that sort of lesbian desire has explicitly been framed as an aggravating factor in some cases. So in summary then, the Wolfenden Report suggested partial decriminalisation of sex between men, and eventually secured it, but at a high price. The harm principle was compromised, and the law on sexual offences hasn't entirely shaken off that inconsistency. Homosexuality became officially a fixed identity to be defined by doctors and courts. There isn't much flexibility in it. There are homosexual men, there are homosexual women, and there's normal people. that's the sort of taxonomy it offers, basically. And some normal people who are corrupted. That's another big anxiety in Wolfenden, which has continued in the law and the courts for both men and women in terms of same-sex activity. For gay men, their inferior legal status was confirmed and embedded for another half century. The price of decriminalisation was the reframing of, or partial decriminalisation, was the reframing of male homosexuality and, by implication, and this new association, lesbianism, as a medical issue for which treatment should be sought, or a matter of pity and toleration. For lesbian women, there was a shift from earlier efforts to keep lesbianism entirely invisible. It was now acknowledged, but in a context where homosexuality was coded as male. So female homosexuality was brought into official being only to be immediately dismissed as a paler, less sexual, less significant version of male homosexuality, in which the subjectivities, needs and experiences of lesbians needed no separate consideration. In other words, it was a new form of silencing, no longer an attempt at complete silencing, but rather the achievement of a near silencing by ensuring that it was overshadowed by male sexuality. And that overshadowing of women's sexuality has persisted into the present and continues to make the disadvantages and discrimination experienced by women in same-sex relationships invisible in many of the contexts where our rights are determined. Thank you.
Say from the outset that I've set myself quite the challenge to talk about Anglo-American relations, McCarthyism and the Cold War in 20 minutes. So I hope you'll forgive the brevity of some of the points that I'm going to cover, which of course are enormously complex questions. Oh, sorry, let me just get my sorry, just give me one moment. I'll just put that into a different view. Sorry. Right. Okay. Let me share my screen again. Okay. So, I'm going to start with World War II, obviously, just as a sort of precursor to the decade that we're interested in. In both the United States of America and the United Kingdom, World War II brought with it particular opportunities for lesbian, gay and bisexual individuals to meet and gather. In America, David K. Johnson notes how the war provided opportunities for men and women to leave home, to live and work in same-sex environments and discover other people like themselves. With a particular focus on Washington, D.C., which is at the epicenter of the American angle to this paper, Johnson observes that the war increased access to Washington's gay subcultures and created more opportunities for same-sex encounters. So in the United Kingdom, as Lucy Robinson puts it, during wartime, a combination of the blackout, military service with the influx of American and Canadian military personnel, and general sense of social flux meant that the metropolitan streets and parks were humming with all kinds of sex. And Peter Ackroyd makes similar observations around the added vein of darkness during the blackouts, which he notes increased the sexual tensions of a world where everything seemed permissible. Robinson points to the post-war decline of opportunities for same-sex enjoyment. But by the end of World War II, in America at least, homosexuality was, to an extent, out of the closet. As Michael Bronski puts it, in the 1950s and early 1960s, homosexuality in America was far from being unspoken, as popular thinking has it. In fact, America was increasingly obsessed with it. Alfred Kinsey's Sexual Behaviour in the Human Male, published in 1948, contributed to this, generally referred to, I'm sure you're familiar with, as the Kinsey Report. And this contributed to the obsession and challenged many previously held ideas about same-sex desire being relevant only to the smallest minority. Bronski comments on the reaction in the United States, noting Americans now understood that homosexuals were everywhere, even if you could not see them. A year later, a similar report was produced in the UK, known as the Little Kinsey, but the results were suppressed at the time due to the scandalous revelations about same-sex experiences and the number of men interviewed who had visited prostitutes. And so, as Caroline has actually noted, perhaps in the UK, there was slightly less enthusiasm for discussing these somewhat unseemly topics. A significant increase in arrests for homosexual behaviour was noted in both the United Kingdom and America in the early 1950s, together with the increased public scrutiny that fostered the sense that homosexuals could be lurking anywhere. This contributed both to the climate of distrust, rumour mongering and suspicion, as well as the lesbian and gay homophile organisations that began to form in America to tackle the legal and social ramifications of a more oppressive society. In both the United Kingdom and the United States, the Second World War provided unexpected opportunities for exploration of same-sex desire and community formation, which was then subsequently stifled in post-war years. And this precursor offers an important insight into moments of if not legal liberation, that sets the stage for the stifling of these freedoms, in many respects directly connected to the Cold War, the fear of the expansionist aims of communism and espionage. So for this paper, I've undertaken a socio-legal analysis that draws on multidisciplinary sources that enables an exploration of the impact of American influences on British politics and culture in the 1950s. These influences, I argue, are important to recognise in the narrative of the path to gay liberation, as the Cold War climate increased nervousness around homosexuals, lesbians, bisexuals, and gender non-conforming individuals holding positions in government, and in particular within the Secret Service. So narratives of gay liberation in the United Kingdom and the United States can invite a shared sense of progress with a broadly similar timeline. Often these stories begin with those landmark moments in the late 1960s, the Sexual Offences Act in 1967 in the United Kingdom, and the riots at the Stonewall Inn in New York's Greenwich Village in 1969, shown on this slide in bold. And as, of course, we've heard from Caroline, the Sexual Offences Act certainly was did not quite mark such a moment of liberation as sort of popular narrative has it. You also have the transatlantic chapters of activist movements such as the Gay Liberation Front, who were an important part of the fight for gay liberation in the 70s. And the timeline of the HIV/AIDS crisis lends itself to a similar narrative of shared advancements and oppressions, parallels, influential exchanges of literature, cultural exports, people, ideas, and movements between Britain and America can be plotted on this kind of non-linear path to gay liberation in a rudimentary, if incomplete, fashion. And of course, when it comes to legal analysis of Britain and America, as Professor Hart himself has observed, certain differences are at least as important as the similarities. In fact, a meaningful analysis of LGBT rights in America requires a state-by-state analysis due to the lack of federal legislative protections. Even today, many landmark Supreme Court decisions, such as Lawrence and Texas and Obergefell and Hodges, are not enshrined in federal legislation. And these cases are also part of a suite of decisions relating to unenumerated rights, substantive due process, and the 14th Amendment, and seem unnervingly vulnerable after the overturning of Roe v. Wade by a supermajority Supreme Court earlier this year. Such considerations are, of course, beyond the scope of this paper, but the caveat is necessary to ensure those distinctions are not erased in the interests of keeping to time. So keeping the points of distinct difference in mind, the 1950s is a time when American socio-political influence on Britain had important legal and quasi-legal ramifications. It shaped positive vetting procedures which restricted the ability of LGBT individuals to access diplomatic and security services. It stoked concerns around LGBT individuals in the military and has been directly linked to the tenacious approach to securing the arrest of individuals such as Lord Montagu. Policing of homosexual activity increased in the 50s, both in Britain and America, in contrast to the period during the war. As Private Dudley Cave observed when interviewed by Peter Tatchell for the BBC, they used us when it suited them and then victimised us when the country was no longer in danger. Whitehall documents declassified in 2011 suggest a similar experience for lesbians. A confidential memo by squadron leader A.P. Doran of the WRAF notes that the official line was to turn a blind eye to lesbians during the war, and expresses how anxieties around the number of lesbians serving in the Air Force became more pronounced in 1956, initiating a prolonged period of surveillance, with further publications suggesting should a lesbian be identified, discharge from service would be the only possible course of action. The 1950s also marked a period of significant cultural exchange, and the decade brought commercial television to British homes and an increased dominating effect of American cultural imports, as John Law describes it. That extended, of course, beyond television to sheet music, records, and movies. The decade also saw an influx of working class Americans traveling to Britain, and American culture and rock and roll cinema and rock and roll were undoubtedly part of the fabric of 1950s British popular culture. Both countries used the ballot box to elect conservative governments, with the Republicans occupying the White House for the first time in 18 years in the early 1950s. Despite these factors, historians generally frame the British public's views on Americana as an uneasy mix of antipathy, suspicion, and distaste, which of course is at odds with the deep political relationship between the two countries. Politically, the importance of the Anglo-American relationship was also often divisive and complex. To dwell too long on this would diverge from the topic at hand, but suffice to say that skepticism of Atlanticism tended to be presented as the purview of the left, with anti-Americanism often causing great anxiety amongst those who saw the value of the special relationship. The substantial loan provided by America to the United Kingdom at the end of the Second World War was described by E.H. Carr as enabling the silent infiltration of American influence into nearly every walk of British public life. The Anglo-American relationship in these early Cold War years involved unprecedented shared military defense and intelligence strategies. America's Cold War preoccupations contributed, as Law argues, to wider British anxieties around the possibility of nuclear war. Dockeray and Sutton have commented that the developments in the United States of America certainly had a particular impact in Britain in the late 1940s and early 1950s, mostly for the worst as far as homosexuals were concerned. As I've identified in my timeline, there were a number of points of overlap, information and strategy sharing, which were highlighted in a relatively cursory way, because it is, of course, impossible to capture all of the key moments. In 1951, for example, the British Foreign Office and the US State Department meet to discuss the homosexual problem. And in 1953, Scotland Yard representatives travelled to Washington to consult with the FBI on the same issue. America was in the grip of the virulent anti-communist sentiments of McCarthyism and the associated Lavender Scare, which framed homosexuality as interchangeable with communism and saw countless individuals denied access to and removed from government posts. David Johnson explains how the Eisenhower administration sought to ensure that America's allies were also working hard to exclude homosexuals from government roles. Johnson further explains that Britain's unique relationship with the United States and a series of homosexual scandals among British government officials led the United States to put extreme pressure on the British in matters of security. And the policies of British security agencies developed over these periods, therefore, to an extent, took cues from their US counterparts. High-profile British scandals undoubtedly made Americans more nervous about the supposed links between communism and homosexuality, and this in turn left Britain's approach to the issue under particular scrutiny. Politically, there was a perceived need in Britain to respond harshly on matters of high-profile homosexual scandals in an effort to restore American confidence in British security services. So Britain's withdrawal of the financial support to assist Greece in combating a communist uprising, President Harry Truman's subsequent vow to tackle expansionist aims of communism, and the related Truman Doctrine offer another example of the significance of the Anglo-American relationship in this period, leading some commentators to ask, somewhat tongue-in-cheek, whether Britain caused the Cold War. The Cold War is an enormous topic, which, as I've already indicated, I can't possibly do justice to today, but it's essential to understand that Cold War anxieties, specifically the sharing of state secrets with Soviets, played no small part in drawing spurious connections between homosexuals and enemies of the state. Jonathan Hogg notes that the knowledge of nuclear danger disrupted broad conceptions of self, nationhood, and existence in British life. And due to the importance of the political relationship between America and Britain and increasing cultural exchange, the Cold War was undoubtedly part of British national and political consciousness during the 1950s in a way that would shape legal and quasi-legal measures. So, the threats to British intelligence were undoubtedly most acutely felt at the start of the decade in the defection of Donald Maclean and Guy Burgess, who fled to Moscow in 1951. Part of what would later be revealed as the notorious Cambridge Five spy ring, Guy Burgess was gay, and rumours abounded that Donald Maclean was bisexual, although that has been questioned by some critics. Guy Burgess worked briefly as an intelligence officer for MI6 before joining the Foreign Office, where Donald Maclean also worked. And both men were sympathetic to the ideals of communism and were recruited well before the 50s by Soviet intelligence agencies. As Rock comments, the revelation that Burgess and Maclean were spies inflicted significant damage on British defence and security and contributed to a loss of faith in British intelligence. It also exacerbated anxieties around the links between homosexuality and communism and played into the hands of individuals such as Home Secretary Sir David Maxwell Fyfe, who focused on targeting homosexuals in government jobs during the 1950s. So the description of legislation that criminalised homosexuality, in particular the Labouchere Amendment to the Criminal Law Amendment Act, carried into the Sexual Offences Act of 1956 as the Blackmailers Charter, speaks to the way the law's criminalisation of homosexuality left gay men vulnerable to extortion, or at least that was the sort of common narrative. As Paul Rock notes, the imprecise and wide-reaching legislation cast a wide net over men who became increasingly nervous about their vulnerability to exposure. And this narrative of susceptibility to blackmail gained renewed focus in the context of individuals who had access to state secrets, despite the fact that both Burgess and Maclean were driven to Moscow by their personal political convictions, as opposed to any such extortion. The fact the law exacerbated the risk of blackmail was recognised by those seeking reform, and the cases of John Vassall and Jeremy Wolfenden, actually both victims of KGB honey traps, which led to the former being turned as a Soviet spy and later prosecuted in the 1960s, fuelled the flames of these connections and ideas. The defection of Burgess and Maclean also contributed to shaping public perception and fostering a distrust of homosexuals who were spuriously conflated with enemies of the state. As Richard Davenport Hines notes, same-sex contacts became more publicised, policed, politicised and punished. Indeed, they were treated as a national menace. Although the British security services would not undertake anything close to the extensive purge of employees witnessed in the United States at the time, the sting in the tail of Burgess and Maclean had a deep impact on LGBT people seeking jobs in MI5, MI6 and GCHQ that stretched well into the 90s due to positive vetting procedures and anxieties around the suitability of LGBT people to hold such positions. And the Anglo-American relationship was a key factor in the development of policies that led to this hostile climate. Following the disappearance of Burgess and Maclean, Sir Alexander Cadogan was tasked with investigating security checks in the diplomatic services staff. A Foreign Office memorandum that was circulated in relation to the inquiry did not see a particular causal link between sexuality and the actions of Burgess and McLean, but rather stated that by far the most important problem is the United States, who certainly saw such a causal link. The memorandum expressed grave concerns over the importance of retaining a relationship of mutual trust with America, leading to the recommendation that homosexuals be eliminated from the service. And this recommendation was subsequently modified to implement a surveillance and positive vetting procedure, which, as Davenport, Hines and others have noted, would become more exclusionary after the partial decriminalisation of homosexuality in 1967, in a climate of aggressive policing and salacious media frenzy. So in terms of other cases, Alan Turing's case is connected to this discussion largely due to his strategic importance in the intelligence services and, of course, his access to sensitive information. However, the events of Turing's arrest suggest it's unlikely he was targeted specifically for his access to state secrets, although, of course, there are rumours that continue to abound around Turing's death by suicide. But in briefly discussing the cases of Burgess and McLean, Turing's nephew Dermot Turing comments, there is no evidence that the Manchester police were mindful of these things or even aware that Alan had secrets of far more significance than those pertaining to his private life. Instead, Dermot Turing attributes Alan Turing's arrest to the vociferous campaign against homosexuals instigated by Maxwell Fyfe. After his arrest in 1952 and before his appearance at the Knutsford Quarter Sessions in the case of the Crown and Turing and Murray, Alan Turing wrote to Norman Rutledge, "No doubt I shall emerge from it all a different man, but quite who I've not found out." Once arrested, of course, Turing was no longer deemed fit to keep his job, which of course was not the worst part of his treatment, but from a legal perspective, which seemed from a legal perspective to be arbitrary and inconsistent with similar cases before the same court. Nevertheless, Turing, along with many others, was a victim of a system which was particularly focused on ensuring there would be no further high-profile embarrassments along the lines of the defection of Burgess and McLean. And of course, Caroline's also spoken about the arrest and trial of Lord Montague, Michael Pitt Rivers and Peter Wildblood in 1954. And this was another high-profile scandal that generated media interest. But again, it has this connection to America. Dockeray and Sutton note that the tenacity with which the law enforcement pursued Lord Montague in particular to secure a conviction was in no small part designed to allay American fears that people susceptible to blackmail were occupying high positions in Britain. So turning then to sort of briefly look at the American piece, because I've obviously discussed how these influences were very much coming from American sentiment at the time. We really have to start with Senator Joe McCarthy. He gave a notorious speech in Wheeling, West Virginia on the 9th of February 1950, which is quoted here in small part. And in this speech, not only did McCarthy pitch the United States in direct confrontation with communism, but also held up a list which had names on it, supposedly all of whom were known communists. And this created and led to this climate of intense paranoia of the McCarthy era. And the Red Scare was accompanied by a keen desire to eradicate homosexuals positioned as communists and Soviet sympathizers from government posts. The threat posed by homosexuals to national security was highlighted in the same year as McCarthy's famous speech through a paper entitled "Employment of Homosexuals and Other Sex Perverts in Government." In this decade, America enshrines God into its motto and pledge of allegiance in response to what was framed as the godless pursuits of communism. Before McCarthy was disciplined in 1954, he and his chief counsel, Roy Cohn, had fired scores of men and women from government employment, with numbers stretching well into the thousands. The persistent conflation of homosexuality with communism prompted President Eisenhower's Executive Order 10450, which made dishonest, immoral, or notoriously disgraceful conduct, including so-called sexual perversion, grounds for firing any federal government employee, essentially barring homosexuals from working in federal government. And even after McCarthy's fall from grace, Eisenhower was able to distance his own program from McCarthyism sufficiently to continue the persecution of lesbians and gay men in government. And the figure of the mythical homosexual enemy was ingrained in American public and political consciousness. When it seemed as though the Lavender Scare might be petering out by the end of the 1950s, the defection of Baron Mitchell of the National Security Service and his friend William H. Martin to the Soviet Union drew immediate speculation around Mitchell's sexuality. Once again, the media latched onto a largely unsubstantiated idea of the men as lovers, reinforcing the conflation between communists and queers. The final case I just want to touch upon is that of Frank Kemeny, Dr. Frank Kemeny, who was hired by the Army Map Service and moved to Washington, D.C. in 1956. By this stage, McCarthy had been disciplined, but the checks designed to keep homosexuals out of government positions remained. And Kemeny was more than happy to frequent gay bars, carefully researching the number of locations that had sprung up around Washington. However, by December 1957, Frank Kemeny had been dismissed from his job, ostensibly on the grounds of failing to provide truthful answers at interview, but in reality, because his sexuality had been discovered. And this moment is an essential precursor to reforms that would follow. Kemeny would never hold another government position in his life, but his legal battle became the first time the question of sexual orientation had been framed in a civil rights context and put before the United States court. Although he lost his case, the argument before the US Supreme Court in 1961 that a federal policy calling homosexuals a security risk was no less odious than discrimination on other grounds was groundbreaking, and it set the stage for further cases of workplace discrimination of LGBT individuals. It was also an unusual case because he made no attempt to deny his homosexuality. Instead, he argued that it was not for the government to decide the morality or otherwise of his private affairs, and the right to privacy is a very important feature of later cases such as marriage equality, Obergefell and Hodges, and Lawrence in Texas as well. So just to sort of wrap it up, I just wanted to briefly look at the sort of growth of the homophile movement as well in the US, which responded to the Lavender Scare and the relentless persecution of LGBT individuals during this period. In 1950, the Mattachine Society was formed by Harry Hay, who ironically resigned from the Communist Party in 1951 due to its anti-homosexual stance. Police raids targeting queer space in San Francisco, and in 1954, raids on lesbian bars, Adler's and Tommy's Place, led to the formation of the Daughters of Bilitis by Phyllis Lyon, Del Martin, and 3 other lesbian couples. And in the latter part of the 1950s, you also get the important Supreme Court ruling of Wanning and Olson, which enabled the dissemination of gay newspapers, magazines, and other publications through the public mail service. Finally, a cafe in Los Angeles that was frequented by transgender individuals was targeted by the police, a moment which led to an uprising that was documented by John Ricci, the author of The City of Night. This is widely considered to be one of, if not the first example of an uprising against the police brutality targeting LGBT communities, yet it is far less well known than the Stonewall riots that occurred a decade later. In many respects, these events and organizations formed in the 1950s laid the foundations for those that followed and are essential to understanding reform. These organizations formed in direct response to the Cold War climate of scares and spies, in resistance to the targeted and persistent persecution of lesbians and gays in public office, and the movements for change that followed owe much to these groups who were active in the 1950s. So there is more research to do and much more to be said about these connections. I'll stop sharing there, all of which have their own complex and at times unwieldy and expansive strands. However, the Anglo-American relationship and the early Cold War climate of the 1950s is a pivotal part of understanding both legislative and social attitudes towards homosexuality, with the spy scandals and the question of national security irrevocably tangled up in the uneasy path to reform and the prohibitions that existed on LGBT individuals serving in secret service and holding military positions in the decades that followed. So to conclude, the links drawn between communism and homosexuality at the time were, of course, ironically, in direct contrast to the views of the Communist Party of Great Britain, and also, as we've heard, in relation to Harry Hay in America. As Lucy Robinson explains, even though homosexuality was often equated with radical and dangerous political ideas, for the left it remained a bourgeois deviation, a product of the very system it wanted to change. Thank you very much.
Right. So this is Professor Gower, Complacent Academics and Legal Education. So in 1950, the Modern Law Review published an extended version of Professor L.C.B. Gower's inaugural lecture as the Sir Ernest Cassel Professor of Law at the LSE. Inaugural lectures rarely generate much interest outside the audience of fellow academics, friends and family who gather to hear the newly appointed professor. However, this inaugural lecture was different. Professor Lawrence Cecil Bartlett Gower, known to all his colleagues inexplicably as Jim, though somebody might be able to enlighten me about that later, was only 35 years old at the time. As such, he was very young to be appointed to a named chair at a prestigious university. Nevertheless, it wasn't his comparative youth, but the content of his lecture, which was to attract attention. Although Gower was a company lawyer, he chose to devote his lecture to English legal training, by which he meant both legal education at universities and vocational training of those who wanted to become solicitors or barristers. His lecture was subtitled A Critical Survey, and it was critical in the literal sense of the word right from the beginning. So his first sentence was, "The subject of legal education is one which has aroused singularly little interest in recent years, and the general professional attitude to it is one of complacent apathy." It becomes clear that by general professional attitude, he's including legal academics, both legal professions, and the judiciary. As we shall see, it was his criticisms of judges which were really to ruffle feathers and draw external attention to his lecture. But both legal academics and the legal professions came in for criticism too. Gower began by contrasting the position in England with that in North America, especially America itself, where he noted the subject is perhaps the most widely debated of any legal topic. However, in his opinion, English lawyers remained blissfully ignorant of this ferment, rarely discussing the problem or apparently realizing that there is a problem to discuss. Is our comparative complacency justified, he asked rhetorically? Are our American colleagues making a fuss about nothing, or is our system so superior to theirs? In the rest of his lecture, Gower critically analysed the whole gamut of legal education, from the undergraduate law degree to the professional training of solicitors and barristers. Each stage comes in for blistering criticism. He first turned his attention to the question of how law should be taught in universities. He wanted to see an end to the situation then pertaining, in which most university law schools acted as law schools for the profession by admitting articled clerks as students for a year so that they could fill the Law Society's training requirements. Since universities didn't generally offer separate teaching for the articled clerks, the effect was to constrict the academic curriculum, because it was only practical to teach all the students at once and the curriculum, therefore, was rather dictated by the Law Society's finals examinations. Better coordination, said Gower, between universities and the legal professions would enable a clear distinction to be drawn between academic legal education and professional legal training. He quoted with approval Professor Wade's inaugural lecture, where Wade argued that law should be taught in universities, not as an exercise in professional technique, but in relation to its place in the world in which we live. He underlined his support for what we would now call a socio-legal approach by quoting with approval Professor Sidney Post-Simpson, who's an American, who said, "Competence in the practical pursuits of the law is promoted far more by an understanding of the law's underlying purposes and theories than by acquaintance with tricks of the trade." Gower was very critical of the undergraduate law curriculum, which he saw as based on the assumption that, quote, "the lawyers we train will devote their lives exclusively to private practice, and all they need is the knowledge of legal rules and skills in applying them to new cases." The consequence of this assumption, he said, was that although some attempts were made to teach statutory interpretation, they were, in his view, half-hearted, and there was little attention paid to public law, despite its growing importance. It was clear to Gower that his students needed something very different from a narrow training in legal technique. The training of barristers also got short shrift. After matriculating, they needed to keep terms by dining for 3 years, during which time they could earn nothing from legal practice, with few opportunities for outside earnings because they could not engage in trade. During those 3 years, the bar finals, the 2 parts of the bar examinations had to be passed. After call, students could read in chambers if they wished. However, as Gower points out, there was no compulsory theoretical training, no compulsory apprenticeship, and no compulsory attendance at an institution. Students were merely recommended to attend the Inns of Court School of Law and recommended to read in chambers. And although there were compulsory exams, Gower regarded them as considerably easier than an LLB or the solicitor's finals. No one, I imagine, he said, would seriously contend that the mere fact of passing the bar final is proof that one is decently well qualified for the duties which a barrister may be called to discharge. It was much more difficult to qualify as a solicitor. After matriculation or passing the Law Society's preliminary exam, students had to be articled for 5 years, during which time they had to pass the Law Society's immediate and finals exams. If they were not a law graduate, they had to attend an approved law school for at least 15 months once they started their articles. Gower's criticisms of solicitors' training were centred on the lack of academic education. Although those without a law degree had to attend an approved law school, the time was actually spent being trained to pass the Law Society's exams. So there was general agreement that the statutory year was of little educational value. When it came to articles, there was no way of guaranteeing their quality. It depended on whether the principal supervising solicitor was conscientious. And even with a good principal, the practical experience based on whatever work the principal happened to be doing could be very limited. The Law Society's final exam came in for particular criticism. The candidate, said Gower, is required to take 6 papers, each of 12 questions, ranging over almost every conceivable subject. Every question has to be answered, and the candidate has only 15 minutes to read, understand, and write an answer for each. Shades of the squee, I think. The result of this approach was that the majority of questions merely tested memory, which was in Gower's view, the crammer's joy. Finally, both branches of the profession were criticised for the financial barriers to qualification, which they did little to relieve. There were some scholarships for those intending to go to the bar, not very many, but the same was not true at all of the solicitor's profession. Both branches of the profession, wrote Gower, value their exclusiveness, and the rules of both branches seem deliberately designed to preserve it by imposing financial barriers in the form of premiums, pupillage fees, and especially by prolonging the period of unpaid apprenticeship. Such practices, he wrote, are relics of the days when wealth and education went hand in hand. But now that education is no longer the prerogative of the rich, and we are all, whatever our politics, wedded to a policy of equality of opportunity, they seem anachronisms. The subjects included in Gower's own suggested syllabus were very conventional, though in terms of approach, he seemed to value a socio-legal approach, integrating what he called non-legal material into the curriculum. He made detailed suggestions for the education of solicitors and barristers and their vocational training, basically suggesting that, they didn't replicate what was done in the undergraduate law degree and taught subjects like conveyancing, which were of much more practical use. The most radical thing he does is to suggest a course on legal ethics. But it was when he turned to the topic he labelled practitioners v. teachers that some more critical elements appeared in the analysis. Noting the gulf separating legal academics from legal practitioners, increased by the advent of university law teaching as a full-time job rather than a task carried out part-time by practitioners, Gower commented that the situation might not be serious if the two sides were regarded as of equal status, but they are not. The academic side is very definitely regarded as on a lower plane, and to a practitioner, academic distinction is not a professional asset, but a liability to be concealed at all costs. It was the next part of his analysis, which would generally have gone completely unnoticed, just like any other inaugural lecture, that was to draw attention. In a remark which means it appears to have been born out of bitter experience at successive meetings of the Society of Public Teachers of Law, the SPTL, he said, "Nothing is more nauseating than the patronising air of mock humility usually affected by one of His Majesty's judges when addressing an academic gathering." He conceded that the situation might be changing as recent addresses delivered to the SPTL have been somewhat less patronising, and he singled out Lord Denning for his encouraging tribute to the value of academic studies. However, the criticism struck home. The judges were outraged that a mere academic should have the temerity openly to criticise them in public. As Cyril Glasser wrote on the 50th anniversary of the MLR, Gower's call for a more critical approach by professionals and academics alike must have been a considerable culture shock for members of the legal establishment. Not only was the attack made by a 35-year-old academic unprecedented, but its tone of sarcasm and the self-confident manner with which the lecturer presumed to sit in judgment on professional lawyers and find them wanting must have seemed little short of a revolutionary attack. After the publication of the lecture in the MLR, the Law Lords summoned the editor of the journal, Lord Chorley, as Glasser puts it, Gower's presumed commanding officer, to be reproved by them for ever allowing such criticisms to be published. This was an inaugural lecture that definitely reverberated outside the lecture theatre. But in Gower's view, it was not the judges alone who were to blame for this state of affairs. Legal academics were partly to blame. Their published criticisms of legal judgments were so moderate and humble that it is sometimes difficult to be sure they're criticisms at all. And, he went on, it is my submission that English teachers of law suffer from an acute inferiority complex, and that this is a bad thing for the profession as a whole. This is a powerful and stimulating article, although it's also somewhat frustrating because of some minor inconsistencies. For example, despite appearing to support a law in context approach to legal education, Gower criticised those academics who thought that universities should not take part in vocational training, but should teach law both to potential lawyers and others as a branch of knowledge like any other social science. So it doesn't seem to me entirely and utterly consistent. However, the main points that he made, the complacent attitude of both legal academics and practitioners towards legal education, the subservience of legal academics to the judiciary, and the patronising attitude of judges towards legal academics, were all carefully explained, evidenced, and justified. He concluded by calling for an inquiry into legal education and training, although he acknowledged this was very unlikely to occur. But he also, more importantly, I think, urged his fellow academics to take a much greater interest in legal education. Legal education, he said, must become and remain a live question. I suppose for us, the interesting question is, to what extent were his views justified? There are lots of examples of people in the 1950s, academics, giving speeches about legal education, endless presidential addresses of the SPTL, which provide evidence of their very, very narrow, conservative with a small c view of legal education. There's an amusing one by Stalybras in 1948-49, who says that we should definitely not be thinking about what the law ought to be, since that gets us nearer to the field of sociology. My own profound conviction at the present day, he went on, is that the first essential of university teaching is that it should be objective, and objectivity is difficult when you come to sociology. I feel that it is one of the great dangers of the increasing development of social studies in the university. So much for a socio-legal approach then. And Gower wasn't the only person to be concerned. Professor Montrose, having listened to a particularly conservative diatribe about legal education at the SPTL, said he could not agree that the task of the law teacher was confined to descriptive exposition of legal rules. Some judgment about these rules had to be expressed. And Abel, Smith and Stevens, in their book Lawyers and the Courts, published in 1970, noted that many, many commentators in the 1950s felt that academic lawyers had not really resolved the dilemma of whether they were primarily providing a liberal education or a professional training. So there were many of the things that Gower said were not unique to him. He wasn't a maverick in that sense. Another interesting question, which I don't really have time to go into now, but I'd like to develop, is how would we fare if subjected to Gower's test of complacency? And what about legal education and training in general? How far has it moved on, and how far are we faced with the same sort of issues as he was? I'm hoping that you might have some views on that later in the session. Thank you. Right, so if I can find my piece of paper, we'll move on to Simon.
Is that how you want to do it, Fiona? I don't know what would help Jeffrey if he's trying to join us. Would you rather have
I think it would help if you just carry on. I'm going to investigate to see if I can get hold of him any other way.
Okay, thanks. Well, thank you very much to Fiona and Rosemary for organising it, this conference and the workshop, and to everybody who's spoken so far. The morning papers I was in were fantastic and very enjoyable. This afternoon, what I want to do is to just spell out some obvious points about broadcasting to do with law in the 1950s. And the first point to make is that it would be a crime against radio to use PowerPoint to do that. So I'm just going to talk in the spirit of those radio talks, which I think were widely enjoyed if by widely you can include the audience of the third programme, which now would be Radio 3, or the home service, which would be Radio 4. By the end of the decade, there was television coverage of law, or at least discussions about law. And an example of that would be the first face-to-face interview on television with John Freeman was an interview of Sir Norman Burkitt, who at that stage was a Court of Appeal judge. And he was interviewed in a very challenging manner, which perhaps we can get to. But to begin at the beginning of the decade, in 1951, the Reith Lectures were given by Lord Radcliffe, Sir Cyril Radcliffe, as he'd been known, who was a serving judge, a law lord. So Lord Sumption and others, but principally Lord Sumption, made a great fuss about his Reith Lectures recently, and how fantastic it was to have a former Supreme Court Justice who just retired. But there'd been two serving judges who'd given Reith Lectures before, Lord Justice McCluskey from Scotland in the 1980s, and Lord Radcliffe very early on in the series of Reith Lectures in 1951. And he talked about power, about which he knew quite a lot, power in the state. And if I just give an extract from the fifth lecture, just to hear his voice. This one was on British rule in India. And Lord Radcliffe, as you probably know, had been responsible for drawing the boundary lines to divide India into India, Pakistan, and East Pakistan. But in this lecture, just 3 or 4 years later, he was talking about the history of British rule in India. So Lord Radcliffe. Can you not hear that?
I can't hear it. No,
Okay.
no, I don't think anybody else can either.
Sorry, I apologise for that. In that case, well, you can imagine that it's a very clipped accent talking about the history of British rule in India. And overall, one could say that these Reith Lectures came across, all the links are there in the abstract. All of the transcripts are available on the BBC Reith Lecture website, but only that particular lecture has the audio. But the overall lectures came across as, I think, complacent, imperial, and very much involved in the machinery of government. Radcliffe was one of those judges, like Lord Sumption, who'd been promoted, if that's the right word, or taken straight to the highest court from being a practicing barrister. In his case, it was partly because of the war, the Second World War, and he'd been brought into the Ministry of Information and had an important role to play in the war. And at the end of that, he was then being asked to do these other kind of roles for government, including sorting out partition. It was said of him that he'd never been east of Paris at the point at which he was asked to go to India and to, in very difficult circumstances, to draw these boundaries. And it was a task accomplished in 5 or 6 weeks, some would say very unsuccessfully. But there were local assessors, and it was a thankless task for whoever had been asked to do it, if they were prepared to do it. So he went on to chair various committees and inquiries, including into the BBC. And people probably know that he fetched up as the Chancellor of Warwick University at the end of his public service, as it began, and got embroiled in a dispute with lecturers, including my own former tutor, Paul Davis. I was a young lecturer at Warwick at the time. but most famously E.P. Thompson, and the student body who were challenging the officers of the university. And they asked Lord Radcliffe to conduct an inquiry into that. You might think it's a bit odd as the Chancellor of the university, but he did that in a reasonably liberal way, saying that the university officers shouldn't be holding information on students' political activities. But anyway, Lord Radcliffe rather got a flavour for giving broadcasting talks and other lectures, including across the Atlantic. There's a book by him called Not in Feather Beds, which refers to the idea of it being a tough life, in which about 20 of his talks are collected. And overall, I think you could say that he didn't seem that interested in his role as a law lord. But he was interested, as the Reith Lectures title suggests, in the relationship between power, the state, elected politicians, and the law. Through the 1950s, there was a series called The Law in Action, not really to be confused with what we know of as Law in Action, where we think of, perhaps now you think of Joshua Rosenberg talking to Lord Panic and others about the latest saga, but in the 1980s, 90s, Marcel Berlins, Claire Dyer, other journalists talking to experts about the legal issues of the day. But in the 1950s, these were not like that. They were a series of broadcast talks. And I mentioned in the abstract that in the 1920s and 30s, the BBC had commissioned women to talk about law. But in the 1950s, these 16 talks were all given by men. I suppose the obvious explanation for that would be that after the First World War, or during the First World War, quite a few men were killed. At the beginning of the BBC, women who had done great things in the war were given the opportunity in the BBC that perhaps they wouldn't have been given elsewhere in civilian life. But by the Second World War, what was coming through was a desire to have voices, whether or not this is right, but a desire to have voices of practitioner authority. And there weren't female judges, for instance, and female King's Counsel, Queen's Counsel. So you won't be surprised at the kind of names of the people who gave these broadcast talks. And one of the things which Humphrey Carpenter points out in his biography, so to speak, of the third programme, was that often they gave the talk reluctantly because they wanted to be in the Listener. The Listener was the weekly BBC magazine, and it had a bigger circulation than the listenership of the programmes. But it was a prize worth seeking in those days. And in other subjects, and this is my point, my interpretation, in other subjects, there were some fantastic lectures or talks which were then converted into listener articles. For instance, this morning, Alan Turing was mentioned. And Alan Turing, the prosecution of Alan Turing and his tragic death, I think, did lead to the Wolfenden Report in the 1950s, and also led to HLA Hart's criticism of Lord Devlin, which we'll get to at the end of the 1950s. But Turing was given quite a bit of time on radio, the third programme, in the early 1950s, to explain whether computers could think, which at the time I think was quite far-sighted, both of Turing and of the BBC. And he gave a talk, and then there was a discussion programme, in fact, 2 discussion programmes a few weeks later. And again, when I provide the written paper for Fiona and Rosemary, if they want to do anything with this, there are links. You can find the transcripts. You can't find, or I can't find, the audio, but you can find the transcripts. At this stage, the BBC was reluctant, even if it appeared to be a conversation, they were reluctant not to have a script. So there's a fascinating material there. For example, in artificial intelligence, Fred Hoyle. So I'm involved in, still at the Open University, the astrobiology project. The research question is, are we alone in the universe? Fred Hoyle wrote about that in all sorts of ways as an astronomer, a space scientist, we might say nowadays. He wrote a science fiction novel, The Black Cloud, in 1957, which I've written about. But in 1950 and 51, he gave talks on the third program about the universe, and they became a book which sold 10,000 copies very quickly in a few weeks. And what had happened there was the producer had heard him in Cambridge, had heard him talking in his Yorkshire accent, and thought it would just make great radio because of the difference in, if you like, in his voice, but the radical nature of his thinking, which was essentially the universe is still growing. And the producer thought, this is mind-blowing, I've got to get this person on the radio. And at the time, in that kind of scientific element, they didn't have a regular slot. So it's quite difficult to follow these lectures. But there are other examples, music most obviously, but lots of examples in other disciplines. Whereas in law, I think it was very, very conservative with a small c. It was about the famous people, including Professor Gower, who talked about a case which was talked about this morning. That is the Savoy takeover bid. And at the time, which is 54, 55, he was in Harvard on sabbatical, and he wrote a very serious article in the Harvard Law Review. But he also gave a talk back for the BBC. It was in the Listener, and it was, I think, the third talk after, certainly Tony Crosland gave a talk on the same topic. So current cases were happening, and people like Lord Gardner, Gerald Gardner, were the people who were asked to speak. In the copy that was published of the Listener, is described as anonymous, because at the time barristers weren't meant to be advertising, if you like, by puffing themselves. Although he wasn't talking about a case he was in, but when it was eventually published as a book, his identity was confirmed, but it was obvious who it was anyway, by definition. So I could go through all of these books, but it's the people you'd expect, like Wade and so on and so forth, who were speaking. So we then get to the end of the 1950s, and we had Lord Devlin's Maccabean lecture on jurisprudence lecture in March 1959 on the enforcement of morals, famously, to which HLA Hart responded in July in the third program. It was on a Tuesday evening in between classical music. It was a 25-minute slot, and it became known. It was about 2 weeks later. It was published in the Listener, only came out weekly. It was published on the 30th of July, so that's the date we often give it. But you can imagine that Devlin gave his lecture in the March. Hart was incensed, arranged to give a talk, and Hart had been involved. Again, Humphrey Carpenter explains this in the history of the third program, with Isaiah Berlin, the philosopher who perhaps made the most, the greatest success of speaking about his subject on the third program. He'd been involved in discussions with the BBC at the beginning of the decade, and he did write to the newspapers about other judges who talked nonsense, in his view, from time to time. And in this case, he gave an excoriating attack on Devlin. Now, we tend to read, if we read it at all, I've written a little book about the Hart-Devlin debate myself, but the little books by them are how we tend to read it. And in the little books, which are a compilation album of their respective lectures, I think Devlin doesn't come off too badly, whether or not you agree with him. Most people don't. By the time of the books, putting together his various lectures, he crafted better response to Hart than he had as an argument in the first place. I mean, it's one of the values of public controversy, I think. But in the initial lecture and in Hart's initial response, I think Hart wins game, set, and match. And the first question which students have asked me about that in the 1980s and 90s, when I was teaching this subject quite a bit, was why was Hart's lecture called, talk called Immorality and Treason? Treason is something which by the 1980s and 90s seemed to be a crime of the distant past. And the answer to that is, I think, an answer to why all these men were appearing, in many ways in the 1950s, which is, even if the public didn't know it, a lot of these people have been significant figures in the Second World War behind the scenes, including Turing, everybody now knows, Bletchley, code breaking. Hart was in the intelligence services. Burkitt, behind the scenes. Radcliffe, behind the scenes. Burkitt was sitting as a kind of judge on detention cases. And he also appeared on radio, if appeared is the right word, he spoke on radio as an onlooker, again, anonymously, during the war, in response to Lord Hawthorne, which was also an anonymous version of events. So these characters, they knew one another, they've been involved in the war. And as I hinted before, I wanted to kind of end with, as radio gave way to television. Burkitt was asked in that first face-to-face interview by Freeman about being a judge in an era of capital punishment. I just want to read a little bit of what he says because it links to the Hart title. Freeman said, Freeman's a very, very direct interview. Do you remember when you gave your first death sentence? Yes, quite well. Did that move you very much? No. Quite contrary to my expectation, I'd always rather dreaded it, but when the actual moment came, I did it without the slightest trace of emotion. What sort of case was it? Burkitt. It was a case during the war. The case where a young sailor had betrayed the position of a convoy to the Germans, and the Germans attacked and sank the convoy. And the charge, I think, was under the Treachery Act. I think the Treachery Act or something of that kind. At any rate, when the moment came for me to sentence him to death, I did it without any emotion at all. Anyway, treason was still in their minds. And the thing which Hart clearly found unforgivable, because Hart knew Turing at Bletchley. In fact, just to digress for a second, I talked to Hart about his wartime experiences, and he was saying that the information was only decoded sporadically, and indeed the messages were only intercepted sporadically. And I asked him what he did otherwise. Was he involved in thinking philosophically? And he said no, he went to work on the munitions production line in Northolt. I mean, he's the gentlest, you'd have thought, most pacifist of people from that generation, which also included the philosophers like Stuart Hampshire and co, who again you would have thought were very left-leaning quasi-pacifists, but they all got stuck into the war effort in various ways, and it shaped them. And so I think this is important in understanding the 50s, at least in relation to the higher echelons of the law, if you like, in practice. These characters knew each other, they'd been through the difficulties of the war. And it was just in Hart's mind, because very, very liberal as well, out of order for Devlin, of all people, to equate crimes such as homosexuality in practice with treason. The idea that if there was a seamless web of morality, and if one bit of it was undermined, everything would unravel. And particularly Hart disliked the way in which, in his initial lecture, Devlin just said it's a question of how offensive and disgusting and so on and so forth people think it is. It's a question of feeling. And Hart came back very strongly and said it's not at all. And one of the things which is interesting for those of us who've written about the Hart-Devlin debate is what to call it now if we revisit it, because Devlin, as you probably know, through the abuse into the inquiry into child sex abuse, Claire Devlin, one of his daughters, identified him as an abuser who committed, was very conniving and created circumstances in which he could commit incest against her. At the very time he was talking about all these issues in the 1950s. So anyway, at the end of the 1950s, I think we have a position in which the scene is set for a switch more towards articles, journalism in newspapers, and the bursting out of periodicals, magazines, and so on and so forth, which took us towards legal literature that we probably all studied. But I think that decade was pivotal and transitional in bringing us out of wartime and in towards the supposedly permissive 60s, definitely more liberal 60s. And at the same time in America, and I'll close with this, we know in the 1950s that there was this liberal Supreme Court, most famously in Brown v. Board of Education, that was making real waves. And over here, there was a fascination with this, but there was nothing like that really happening in our own legal system. So it's fascinating, I think, for us to look back at that decade. And finally, as somebody who was born in 1957, just 3 days after the Treaty of Rome was signed, it is extraordinary to me, looking back now, that I started teaching over 40 years ago. 40 years from when I was born was the First World War, let alone the Second World War. You know, so in a very short space of time, or at least the time that I can remember, or an equivalent time with, we've had huge social changes. And the BBC was one of the bright results, if you like, of those changes in the 20th century in the United Kingdom. And so I think you're spot on in saying it's a neglected decade, but it's a very important decade in our understanding, the public understanding of law. Thank you.
Okay, well, I think the topic of the topic of looking at legal studies in the 1950s is a most interesting one, and I thought I would come in with some thoughts on Roman law. When I started my sort of research for this particular talk, I hadn't been aware of Paul Mitchell's paper on F.H. Lawson's book, Negligence in the Civil Law. And this is a paper that is very relevant to this whole topic of the 1950s. So in a way, I'm going to shift the focus off Lawson and on to sort of other aspects of the 1950s. I guess I should, well, I expect all of you do know quite a lot about the history of Roman law, but for those of you who don't and want to know why was Roman law taught up until the late 1960s as a mainstream, or if you like, almost as a core subject, the answer lies in the 1846 report on legal education by a parliamentary select committee, published in 1846, whose conclusion was that there was no such, no legal education worthy of the name existed in England, Wales, and of course Ireland at the time. They recommended that the universities start teaching not just law, but science of law. Now the question is, what was science of law? And various professors at the time, in particular George Long, took the view that it was Roman law. So Roman law comes into the curriculum under the heading Science of Law. And the reason for this, of course, is the Select Committee also recommended looking at the legal education system in Germany, which at the time, the mid-19th century, was regarded as the finest. Germany was regarded having the finest education system in the world, thanks, of course, to the influence of jurists such as Carl von Savigny and his successors. And they had attempted to turn law into a science, and it is still, as you may know, a science today. It has a place at the Max Planck Institute, and many German jurists regard themselves as scientists. So Roman law comes in as legal science, and it then gets taught and becomes, over the years, just like any other positivist subject. There's a vast amount of Roman law, so quite a lot of technical detail to get through. And so what I think most of the courses ended up in the developing universities as law faculties developed and were established during the 20th century. What happened, I think, is that it just became another positivist law subject, really. And you started, I mean, I've got some notes here looking at the contract of locatio conductio, and it's set out like a textbook. What are the duties of the hirer? What are the duties of the lender? Well, as if it's some kind of some kind of modern positivistic subject. And as I say, the other courses you would have probably, I mean, my own experience at Cambridge before 1970 was that you had to do a compulsory course in the first year, general course, really based on the Institutes of Gaius and Justinian, covering all topics, persons, things, and the law of actions. And then in the second year, you did a compulsory course on the law of property and the law of obligations, actually, which I found, thanks to Colin Turpin teaching it, to be rather a fascinating course. And I'm in the process of actually trying to publish his lectures, or writing them up and publish them, because I think they were quite advanced for the time. And then the other way you did it was a number of specialist papers, and what often these specialist papers would involve is picking a particular title from the digest. Theft, for example, was one I did. Law of actions was another. Of course, you could imagine delict was another I did. Contract, various types of contract, locati against society, whatever. And they tended to change. So that was the way Roman law was taught. And I don't think anyone really, as far as I could see, really questioned it until we get to the 1950s. And then I think we do begin to see, not just in the UK, but particularly in France, with the legal historian Michel Villet, who is both something of a legal philosopher as well as a legal historian, but also a specialist on Roman law and taught many of the Roman law courses. He was what was called Paris II then. And he started to write in a series of articles in the 1950s, beginning to, shall we say, open up Roman law in a more theoretical way. One of the way he used Roman law was to write a huge tome, which actually only got sort of published by Paris II. It didn't actually get published by a major publisher until well after his death in 1988. A huge kind of 700-page word called basically on the history of the development of the subjective right. So he's beginning to look at, we see in the 50s, a debate opening up as to, did the Romans have a notion of right, the subjective right? Now, he wasn't the first to note this. Actually, Henry Maine had noted this in his Early Law and Custom, but still, Maine didn't seem to have the influence. You've got all these translations of the digest by Monroe and such like, where the term use is translated as a right. But Villet opens it up with a theory. He says the Romans didn't have a notion of a right. The notion of use meant something really rather different. It meant more of a kind of legal relationship rather than the idea of a subjective power. And his thesis was that the Romans did not regard ownership, dominion, or proprietas, the two terms to be found in the digest using for ownership. They didn't regard it as a use. A use was restricted in the law of property to rights in another's property, a servitude, a usufruct. And so his thesis was, it wasn't until the post-glossators that we begin to, you see the it might have even started with the glossators writing in the 13th, 12th and 13th century. They merge, he argued, use and dominion, and therefore brought into this word use the power, the potestas that attached to dominion. And then this was developed by the humanists in the 16th century, particularly by Hughes Donogh, into the notion of a subjective right. Now we see this happening in the 1950s. So what I think is interesting about Roman law in the 1950s, it's beginning to kind of open up, beginning to break out of this highly positivistic, we're only going to look at, you know, Roman law from the Republican times until Justinian, and then, you know, with the death of Justinian, you know, that's it. We don't go any further. I think that particularly with some of the English professors, such as Herbert Jolowitz and Raphael Powell, and of course F.H. Lawson at Oxford, De Zulita also at Oxford, I think they were beginning to appreciate that actually you couldn't just look at Roman law, you know, sort of within the time capsule of just Rome, because so much of our modern understanding of Roman law has come through the jurists of the second life of Roman law. Let me give you one silly example of this, that we, you know, looking at I dug out all my kind of old lecture notes for this talk. I can see that quite a few of the lecturers would use the word detentio as a kind of opposite to possessio, to possession. If I lent hired goods to somebody, of course we know in English law through bailment, the hirer gets possession, but that was not the same in Roman law. They only got detentio, detention. But actually the word detentio is not to be found in the digest at all. Actually, it's used by the first use I can find of it is through Bartolus. You know, there's a lot of kind of expressions. So in other words, quite a lot of the work of the post-glossators is sort of thrown back on Roman law itself, and actually was giving a distorted view of Roman law. And this was true of the way in which we talked about rights, you know, the rights of a seller in a contract of sale, or the rights of a buyer in a contract of sale. Well, you know, I'm not entirely sure Romans thought in that sort of way. They thought in terms of actions. Now, I think jurists such as Herbert Jolowitz were beginning to appreciate this. And he set out in the 1950s, early 1950s, to write it was going to be a multi-volume work on you know, the Roman it was called the Roman Foundations of Modern Law. And he was taking the starting off with the Roman materials and then going through each century from the rediscovery of Roman law in the 11th century, going through what the post-glossators, what the humanists, natural lawyers, pandectists, how they, if you like, developed, if I would use the word sometimes, distorted the Roman law, and how this then reflects back. And this was a point that Ville always made. I had a slight acquaintance of Ville because I attended quite a few of his seminars just before he died in the 1980s. And he was always making this point, you know, you can't understand Roman law unless you know it's what is called the history of its second life. You've got to know Donogh, the post-glossators, Donogh, you know, Savigny, because you know, you're making, let's put it this way, you're making a historiographical problem if you think you can access what the Romans really thought. And I think what's important about the 1950s is that this was beginning to filter into Roman law teaching and Roman law writing of the time. And it's also useful to remember that someone like Herbert Jolovitz, a Roman lawyer teaching Roman law, was also a legal theorist. He held the Quain Chair of Jurisprudence, and of course he gave lectures on jurisprudence, which were published by his son Tony Jolovitz in Athlone Press, 1963, which is still unfortunately it predates Hart, Dworkin, and many of the kind of modern theory, but it's still a rather interesting history of, if you like, legal theory. And so another aspect then of Roman law in the 1950s, it's beginning to kind of open up and go off in a direction of both legal history, as I've suggested. By that I mean the whole gamut of history from Roman times up till the Pandectics, up indeed till the 20th century. And it was beginning now to filter into jurisprudence. And that, of course, had happened before the 1950s. Pollock's early book on jurisprudence, of course, has, if you look at it, has lots of Roman law in it. Markby's Elements of English Law is much the same. You can see how, you know, the so-called legal science going into jurisprudence and now. But I think in the 1950s, Roman, what we might call kind of black letter Roman lawyers were beginning really to, if you like, try and open up Roman law to show its importance as underpinning aspects of legal theory, aspects of private law, and a range of other aspects, and also beginning to question in a major way the translations. Have the translations into French, into German, into English, do they accurately reflect really, the mentality of the Romans, if we could ever get into it, or are these translations really just a kind of modern view of Roman law? And I think that's a big danger that was beginning to be appreciated in the 1950s. But of course, it's difficult just to say this happened in the 1950s. We see an earlier book, which I still think is one of the finest books on the history of legal theory to have been written in Europe. I haven't found, not that I'm an expert on all the German material, but I haven't found a better one in Italian or in the French materials, is J.W. Walter Jones's A Historical Introduction to the Theory of Law, which was published by OUP in 1940. It is an extraordinary work that the Jones's grasp of, the Roman law, he knew Bartolus, Baldus, all the post-Clausators backwards. And when his chapter on economics and law, he knows all the American cases as well for the time. So it's an extraordinary work. And I think that was a sort of forerunner of how people were going to start thinking about Roman law in a wider context in the 1950s. But of course, as we get into the 1960s, the kind of 60s revolutions, a more, very much, a generation of critical students who started to ask, why on earth are we studying this Roman law? It's of no use to us. And we're just learning a lot of material for no apparent purpose. Some sort of said it'd be much better to do, a course on arbitration or something. And so by 1970, I actually literally did the last year of the old syllabus at Cambridge. If I'd gone a year later, I would not have been able to do the Roman law that I did. And it didn't disappear. Peter Burke's fought a rearguard action, as I'm sure all of us know, at Oxford, and he's written about how when he was away, they tried to abolish Roman law completely, which is a terrible story, really. One of terrible bad faith, I think. And so we're left today with almost, many younger academics have no idea of sort of Roman, the importance of, you know, what Roman law can contribute to legal thinking. And I'm just going to end on an example. I was in a seminar quite recently about equity, and the question was whether equitable rights in property were either sort of rights in another property, or were they part of ownership? Was there such a thing as, you know, fragmented ownership? And when I pointed out that this was a question discussed by the Roman jurists, people looked at me as though I'd come from another planet, and that it was just an old problem, and what was happening was a reinvention of the wheel to some extent. So just to sum up, I think the 1950s is an interesting period. I think we see a number of Roman law books, as Paul Mitchell's article shows. F.H. Lawson's Negligence in the Civil Law is really quite a radical book because, as Mitchell explains, he questions really the relevance of Roman law and fault liability in an age of motor vehicles and industrialization. And that's pretty radical for the early 1950s. We also see the beginnings of what was to be a major work by Jolovitz on the modern foundations, the Roman foundation of modern law. Unfortunately, he died after quite early on, and so it never got finished. Only one slim volume, a wonderful book, I think, again, got published. But had he lived, I think we would have seen a multi-volume work, which would have been a very valuable contribution. And we've only really seen a modern version, a sort of version of that, with Reinhard Zimmermann's Law of Obligations, published in the UK in 1996 by OUP. It's published a little bit earlier by Juta in South Africa, and you know, a few others. David Derrison in France has written a history of the French law of obligations, and he told me last week that he's writing history of the whole of the law of obligations in Europe, which strikes me as lunacy, but from Roman times to modern times. And so there we are. So, you know, some of the work from the 1950s, if you like, is being taken up again by legal historians today. On that note, I'll finish. I think I've done my 20 minutes.
You have, and thank you very much, Jeffrey.